you so much.
Thank you.
Bye.
Good morning, Mr. Valle.
Morning, miss.
Do you need an interpreter this morning?
I can talk. The only thing is I don't understand some words. Well, I can understand.
Okay, so if you need, so we have an interpreter here for you, and if there's something you would like
Alright.
translated, just let me know.
All right, thank you.
Thank you. We're gonna get started in just a moment. Mr. Valle, I'm going to swear our interpreter in just in case you need her.
All right, there we go. I need to say something before everything starts. So,
Good morning, Liza Revere. Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that you will faithfully discharge according to law your duties as an interpreter to your best of your abilities, so help you God or upon penalty of perjury? I do. Thank you. That was a swearing in the interpreter. Thank
I
you.
wanted to say something. Did you want to say something?
This is your attorney.
Right. Did you want to say something?
yeah, I try to talk to you because I never explain the situation why me run for the half an hour, you know, and I got an issue
Mr.
with the
Valle,
half
before
an
you
hour.
continue-
And
Hold on, Mr. Valle. Before you continue, you are live streaming and this is being recorded. I haven't read you your rights yet, but I'm just you're speaking to your attorney. But I do want to just let you know that you're being recorded and I have not read you your rights or anything like that.
okay. So I can talk then.
Not right now. You wanted to talk
All right.
about where you're going to be. Did you want to talk about where you're going to be placed when you're released?
Yeah, that too.
Okay. Well, there's a procedure. Do you want to go forward with this hearing today?
Yes.
Okay. So then we'll talk about where you're going to be placed later.
All right.
All right. Thank you.
Well, good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jorge Valle 323702. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
323702.
I'm sorry, can you just repeat your name one more time?
Valle, George Valle, 323702.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Attorney Robert Famiglietti of the Parole Revocation Unit of the Public Defender's Office.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, A supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Valle, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, you can lower your hand. Yes, thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. Oh, you can lower your hand.
I think he's raising his hand because he wants to say.
You want to say something?
I can talk now.
Sir. Okay.
Nah,
So- No, it's not your turn to talk, sir. So
All right.
there's a procedure, a process that we go forward with in this hearing. And then at the end of the hearing, before she makes her findings, you can be heard. But now is not that time. We will let you know.
Thank you.
Thank you.
If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Now, do you have any questions about the purpose or procedure before we begin? Not about the charges, but about the procedure of this hearing. Do you have any questions?
No, I'm all right.
Okay. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So, Mr. Valle, I'm going to read the charges. You will have an opportunity to speak regarding the charges, but first I'm going to read all of them, okay?
Okay.
Charge 1, absconder. On June 4th, 2024, at approximately 1:25 p.m., you were observed on camera leaving the Maple Street halfway house without permission, and you failed to return to the Maple Street halfway house, which is your only parole-approved residence, and you failed to reside at this residence since that time. You failed to contact your assigned parole officer and halfway house staff, which means your current whereabouts are unknown. Charge 2, drugs. On February 20th, 2024, you signed a voluntary admission form admitting to using fentanyl. On March 28th, 2024, you signed a voluntary admission form admitting to you using cocaine on March 22nd, 2024. On April 3rd, 2024, you signed a voluntary admission form admitting to using fentanyl and cocaine on April 2nd, 2024. On May 28th, 2024, you signed a voluntary admission form admitting to cocaine and heroin on May 26th, 2024. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, signed parole conditions. Exhibit F, signed halfway house agreement. Exhibit G, voluntary admission. Exhibit H, signed misconduct. Exhibit I, voluntary admission. Exhibit J, voluntary admission. Exhibit K, signed misconduct. Exhibit L, app referral. Exhibit M, signed voluntary. Exhibit N, signed misconduct. And Exhibit O, Maple Street incident. Counsel, you received a notice of parole violation report, and the other documents that I just marked for identification purposes?
Yes, I am.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. It is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Yes, I've got no comment as to the preponderance standard as to the drug charges. However, regarding the absconder charge, my client's underlying crime was an intent or an attempt to take the life of someone else. It was not successful. The victim's family, known to the PO, known to the halfway house, someone was looking to kill him. The PO knew that. It's not in the report, but the parole officer was made aware of that. The halfway house was aware of that, and they were advising a move to move him to either Norwich or Hartford. My clients, there was word on the street. This was well-known, established fact. And for whatever reason, parole did not move him. He feared for his life. He kept telling the people at the halfway house and parole, they did not move him. The move was never made. My client was scared, and he left the halfway house for fear of his personal safety. He left out of necessity. He did not leave because he wanted to avoid his responsibilities, reporting to parole. He did not leave because he didn't wish to obey the rules. In fact, he abided by all the rules. The only misconducts are for 3 drug positives, and he completed an app referral and also went to evaluation at Connecticut Renaissance. So he did everything he was supposed to. He was there from January to June when he left, and he was remanded in November. No new crimes were committed. He was on the run to save his life. And so I don't believe the elements of absconder can be met. Thank you.
Thank you. Now, Mr. Valle, do you want to say anything in addition to what your attorney already put on record?
Nah, the only thing he said basically everything. So the only I said I'm apologize because I'm wrong, but I don't feel safe for my life, you know. So that's the only reason. But I want to continue on the street. I get married, and when I'm in the wrong, I get married. I got a family now. I got a wife, you know. So my priority now is being a halfway house on the programs to getting my job to take care of my people and my family, you know.
Thank you.
Thank you.
We can talk more about your plans in the future once the findings are made. I will speak. We filed an exhibit. I will speak to your past, present, and what you want to do in the future. And if you have anything to add, then you can, okay?
All right.
I'm just going to take a moment before I announce my findings. And before I do that, Mr. Valle, is there anything you wanted interpreted that you didn't understand thus far? Do you understand everything that's happening now, or would you like to use the interpreter?
Yes. Nah, I understand.
Thank you.
On charge 1, absconder, I make a finding based on state's exhibits B, E, and O, as well as testimony today. On charge 2, drugs, I make a finding based on state's exhibits B, E, and G through N. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, there's no doubt my client had a drug problem. If he hadn't left, and he left out of necessity, like we argued, this is an unusual, unique situation. This would have been a perfect top. He was referred as a result of those positive urines and successfully completed ACT. And he did that from April 2024, April 8th to May 8th. And then beginning on May 8th, he was at the Connecticut Renaissance Halfway House program. And he did an evaluation there. So my client is a married 39-year-old gentleman. He receives his support from his mother, 2 brothers, and his wife, Miss Rivera. He now has 3 stepchildren that he's very interested in also supporting. In the past, most recently, he was employed as a barber. He's worked also in the past at Park City Green, a mattress recycling facility in Bridgeport. He was there, but he had to leave ultimately because he has asthma, excuse me. As I stated, he completed the App Foundation. He was participating at the Renaissance in individual and group therapy. In the past, he's also completed an IOP, and he was on the waiting list for a domestic violence program, although that is not part of this violation whatsoever. He receives medical assisted treatment in the form of methadone. Upon release, he wishes to be sponsored by his wife, correct, sir?
Yes.
And that would be in Waterbury. And then as a backup plan, he's amenable to be placed in a halfway house in Waterbury. He's amenable to all job opportunities And like I said, this is a unique set of circumstance. He's not a danger to himself. He's not a danger to the community. We wish that he be released as soon as possible because we don't believe the nature of this violation is so significantly serious to warrant further incarceration. He's been held since just before Thanksgiving. We don't believe further confinement is necessary or appropriate. All of his prior issues have been as a result of drug use. Thank you.
Thank you. Mr. Rajay, is there anything you'd like to add that your attorney did not put on record?
He said basically everything.
Okay, thank you. Now I'm going to take a moment before I announce my recommendation. Okay, Mr. Valle, being that this is your second violation, your first violation occurred about 4 months after being released on special parole supervision, at which time you received a criminal conviction. Then from there, you were released, you received a sanction, you were released. Upon your release, you were supervising in the community for approximately 5 months prior to absconding from parole supervision. And then your whereabouts were unknown for approximately another 5 months. Taking that into account, and prior to absconding, you also received 3 misconducts for ongoing use. I'm also taking into account that you did participate in and complete treatment. But being that this is your second violation, you absconded this violation, your whereabouts were unknown for 5 months. I recommend revoke and re-parole on June 25th, 2025, which is an approximate 7-month sanction with the following conditions: anger management, no contact with co-defendants Jonathan Marciliano, Ralph Green, no contact with victims CN and ED, halfway house placement in the event that it is needed, and a mental health evaluation. My findings and recommendations will be forwarded to the board, and you will receive official written decision from the board, and your board review is scheduled on February 6, 2025. Now, on that date, the board is going to take a look at your case. They can lessen my recommended sanction, they can keep my recommended sanction, or they can exceed my recommendation, being that you're on supervision until October 2033. And if they do exceed my recommendation, another hearing will take place, and they will outlining the reasons why they want to exceed my recommendation. Okay?
Do you understand that, sir? Her recommended release date is June 25th. It's up to the board now. They'll meet on February 6th and make their final decision. Okay, sir?
All right.
Okay, thank you. This concludes your revocation.
Call me if you have any questions, sir, okay? Call me,
All right.
okay? Thank you.
Just give me a second so that you know who's not needed.
Good morning.
Hi, good morning.
So we should have a few with you this morning, Mr. Yakubu,
Yep,
McElroy, and Perry.
correct.
If we could get started with Yakubu, that would be great. Is he there?
Okay. Yes, I have them all.
Awesome. So we'll just go down the list.
Okay, so Yakubu, then Perry, and then McElroy.
That's fine.
Okay. Okay.
Thank you.
Thank you. Yep. Yakubu.
Good morning, Mr. Yakubu.
Good morning.
Am I saying your last name correctly, Yakubu?
Yes.
Okay, we're gonna get started in about 5 minutes. I'm getting your attorney as well as your PO on the line.
Thank you.
Thank you. Good morning, PO DeVylder.
Good morning.
We'll get started in just a few minutes. morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Muhammed Yakubu 366932. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Muhammed Yakubu, inmate number 366932.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Yakubu.
As well as your parole officer.
Parole Officer DeVylder, Hartford Special Management Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact on each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Yakubu and P.O. DeVylder, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officers bring against you, and the information underlying each charge. Charge 1, obedience to the law. P.O. DeVylder.
According to Hartford arrest warrant CFS 2400235595, at approximately 5:17 p.m. on 6/18/2024, you were involved in a motor vehicle accident and fled the scene. Connecticut State Police were dispatched to the scene of the collision, where there was damage to the complainant's vehicle's rear bumper and tow hitch. The operator of the damaged vehicle was able to provide the license plate of the evading vehicle, which was registered to your girlfriend. When CSP made contact with her, she identified you as the individual that was operating the vehicle at the time. On 6/19/2024, the investigating trooper made contact with you via telephone. You admitted that you did strike the vehicle and fled the scene. A request for an arrest warrant was drafted and probable cause was established when it was signed by a judge on 9/4/2024. On 10/2/2024, Connecticut State Police served you with the warrant and charged you with evading responsibility, 14-2024 B3, and following too closely, 14-240B. Subsequently, you were transported to Hartford Correctional and a remand to custody was lodged by parole staff.
The state has filed the following exhibits, starting with Exhibit A.
Parole conditions. B, parole violation notice. C, parole violation report. D, remand to custody. E, State of Connecticut Judicial Branch pending case detail. And F, Connecticut State Police arrest warrant 2400235595.
The state has filed an addendum to Exhibit C, which states on December 23rd, 2024, Mr. Yakubu's charges of evading responsibility and following too closely were substituted to failure to stop. As a result, Mr. Yakubu received a $100 fine. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
I did. There were 2 addendums that were filed. Can you put the first one on the record also, please?
The first addendum states on December 23rd, 2024, Mr. Yakubu case for evading and following too closely was disposed of, and he was ordered to pay a $100 fine.
Thank you.
And did you receive the document?
I did.
And the defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. At this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. DeVylder?
Yes, I would just like to make a quick note for the record. Regardless of the court's outcome, we are here because of the criminal behavior of Mr. Yakubu. He was operating a motor vehicle, which he admittedly hit and damaged another vehicle. Yet he left the scene because, and I quote, "I had to poop real bad." Any law-abiding citizen knowingly involved in an accident would have relieved themselves and made an effort to go to the police station or at least make a telephone call to take responsibility for their behavior. Instead, Yakubu went home and went to bed. He did not try to resolve the situation, nor did he even report it to me until weeks later after I received notification from the police. Because of his negligence, the police had to execute a criminal warrant for his arrest, which led to this remand. The outcome of the court is irrelevant as Yakubu intentionally left the scene of a crime and did not handle his responsibility appropriately. Thank you.
Thank you. It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes. Regarding the parole officer's comments regarding the conduct she charged my client with on the parole violation report was not the same conduct that he was presented with in criminal court. I'm going to provide you with some information which is dated December 23rd of 2024. My client was not presented an evading responsibility for following too closely. I understand the parole officer's comments regarding what occurred, and she referred to it as the outcome from court. But what she charged him with was not even presented in court. And I have some questions for the parole officer. I can't pronounce, I always butcher her last names. I'm about parole officer. Pio, do you recall a phone call I made to you on January 10th of 2025 regarding Mr. Yakubu?
I do, and I was instructed that it needed to go before the board and that I am not to talk to you.
Okay. Do you recall me questioning you regarding the first addendum that was put on a record regarding case for evading responsibility and following too closely was disposed of and was ordered to pay a $100 fine? Do you recall me telling you that that information was not correct?
It wasn't that it was not correct. It was just the wording of my addendum.
Okay. And I asked you, do you recall me asking you if you had the substituted information from court?
Sir, this is irrelevant. He was arrested on a
It's not
warrant for
relevant.
evading
She needs to
responsibility.
answer my questions on the record. She's under oath and I have a right to defend my client. She has to answer she can't take the fifth. That's not the way this process works.
Could you repeat your question?
Yes, my question is, was she aware of the substituted information that was presented in court?
What substituted information that was presented in court, sir?
The information that I emailed you, which you didn't have, and I have a copy of the email I sent to you.
And the addendum is correct?
Did I email you some documents that provided you with the substituted information from court from December 23rd of 2024?
Yes,
Okay.
but the substituted information has no relevance to why we're here today.
In your opinion, I'm entitled to my opinion. Now, you're under oath. I have some questions and you need to answer the questions. That's your job.
Continue.
So the follow-up question is, do you recall you telling me after I sent you those information that you're going to check with your supervisor and you were going to call me back and you asked me for my cell phone number? Do you recall that conversation?
I do. And then when I went to my supervisor, I was instructed that at no way, shape, or form are you supposed to be contacting me directly, and that it's going to go to the board before a revocation hearing, and I am not supposed to speak to you.
Okay, that's fine. That's PCS position. That's fine. I provided you with the information you didn't have. Then on January 13th, you filed a second addendum, which you sent to PO Munis. Is that correct?
I did.
Okay. And that second addendum had information which I emailed to you, which I provided to you, which you didn't have on January 10th. Is that correct or not?
Yes.
Okay, thank you. I'm asking that a no finding be made. The charged conduct was not presented in court. The original addendum, as P.O. DeVylder indicated, the wording was not correct. It wasn't just the wording. The substituted information is very relevant because it's not where an initial charge was nollied or was dismissed. That conduct was not presented in court. Did I hand that over to you? I'm sorry, I started to. This is the court documents that I was able to obtain through my investigator. That is the charge that he was presented with in court, which is an infraction. There are no charges
May I
that were not.
interrupt?
You're going to definitely have P.O. DeVylder, you'll have another opportunity to speak. Absolutely. But
Thank
I'm
you,
going
P.O.
to have
Sanders.
pro officer, or I'm going to have Attorney Sirica finish his thought.
Thank you. That's the charge that was presented in court. It wasn't a situation where charges were nollied or dismissed. That was the singular charge that my client was presented with in court on December 23rd of 2024. That is a copy of the clerk's information sheet, which I emailed to the parole officer with a couple other documents, which lists what happened, who the judge was, who the prosecutor was. So prosecutor's discretion file the substituted information. That's who files that, the state's attorney's office, not the defense attorney, obviously not my client. That's what he was presented on in court, which is an infraction.
Okay. So I'm going to mark this as exhibit number 2 from the defense. Okay. Anything further before?
Not at this point.
Okay. P.O. DeVylder?
I would just like to reiterate, he was remanded on a warrant for those charges. What Sirica is referring to is a further court date of December 23rd, which Yakubu had been in court multiple times before that. He had been arraigned on the charges of evading responsibility. Regardless if the attorney subbed it down to an infraction is not the point. The point is he had a warrant for criminal behaviors for the evading responsibility.
Anything further?
No.
Thank you. Counsel? Anything? Okay. I'm going to take a recess before I announce my findings. So it's going to just be a moment. I'm going to step out.
Hello, good morning, welcome everybody. How is everybody doing today?
We are now back on record. Taking into account both the state as well as the defense arguments today, on charge 1, obedience to the law, I make a no finding on the following charge. Following too closely, as this charge is an infraction, which is neither a crime nor an offense. I make a finding on a parole violation for the rest of this charge based on state's exhibits A, C, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history.
I apologize, but I need for you to repeat that one more time, what you just put on the record.
So the charge, based off of the PBR, he was charged with following too closely and evading responsibility. I make a no finding on following too closely as that's an infraction, because that's not considered a crime nor an offense. But I do make a finding on evading responsibility.
Thank you for clarifying that.
Pierre DeVylder, do you wish to make a statement regarding Mr. Yakubu's background and history at this time?
No, thank you.
Counsel, do you wish to make a statement?
Regarding his background?
History,
Yes, I do. I am asking for my client to be reinstated as soon as possible, based on those findings. If my math is correct, my client was paroled, looks like on July 28th of 2021. It's not remanded till October 2nd of 2024. My client, he's 38 years old, is out in the community for 3+ years. Once again, if my math is correct. He was placed at the the REACH program. He was there until he was remanded on October 2nd of 2024. He did have a full-time job prior to his remand. He had good work history, but his last job for the past 2 years was full-time employment for Dun Paper, which is now called By Origin Specialty Products out of East Hartford. He had good job with good benefits. He reported to us. He did briefly work with individual therapists at CRT in Hartford until he got a job. And while he's been, since he's been incarcerated at Robinson, he's working as a chairman, doing cleaning bathrooms and showers, etc. He would like to return to the department through the REACH program in East Hartford. He said that was the best thing that happened to him. He liked where he was and said he was out for 3+ years. And at some point, he'd like to enroll in Tractor Training School to obtain his CDLA license. And he's indicated to us he can return back to his full-time job at the paper place. Thank you.
Thank you. I'm just going to take a moment before I make my recommendation.
P.O. Saunders, can I just make a quick statement?
Oh, yes, absolutely.
So the REACH program is usually only available for a 6-month duration. Yakubu was there for approximately 3 years. So at this time, that apartment is no longer available to him. So I would just recommend a halfway house stipulation be added to his conditions for a halfway house placement. I think he wants the Hartford area, if I'm not mistaken.
Is that correct, Mr.
Could you
Yakubu?
just clarify that? She beat me to it. I was going to ask Mr. Yakubu, what part of the state do you want to go? Hartford, your parole officer knows you a lot better than I do. Is that where you want to go?
Yes, I want to go to Hartford because it's closer to the job.
Okay, perfect. Thank you.
Anything further, P.O. DeVylder?
No, that's all.
Thank you. And Councilman
I don't have anything else to add.
Mr. Yakubu, is there something you wanted to say?
Yes, is there any way I can get DeVylder as my PO back again? Because she was a good PO and I'd like to continue with her.
I don't think, if I misspeak, please correct. We don't control that part of it, Mr. Yakubu. Once you get re-paroled, that's up to the field office. I don't have any control over that. Neither does the hearing examiner. That's great. You had a good working relationship with her, but we don't control that here.
Okay.
Thank you. I recommend revoke and re-parole on February 6, 2025, which is an approximate 4-month sanction, with the following conditions: no consumption of alcohol, no contact with co-defendants James Tyson, Earl Gelman, and Sherelle King, no contact with victim LM, a general no contact with SMC, halfway house placement, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board. you will receive the official written decision from the board, and your board review is scheduled on February 6, 2025. On that day, the board's going to take a look at your case. My recommendation is for you to be released on February 6th. So they can agree with that recommendation, and being that you're on special parole, if they agree, you would be released on February 6th. If they don't agree, they can exceed my recommendation, being that you are on supervision until May 2032. And if they do want to exceed my recommendation, then another hearing would be held so they can explain why they want to exceed my recommendation of a 4-month sanction. Okay, any questions?
No.
So Mr. Yakubu, you will know if the board adopts the recommendation if you get released on the 6th, because it goes to the board at 9 o'clock in the morning. If they adopt the recommendation, you get released that afternoon. Okay?
All right.
All right, good luck to you.
Thank you. This does
Thank you.
conclude your revocation hearing. Thank you.
Thank you.
Thank you.
Thank
P.O.
you.
Father.
All right, thank you, Mr. Valle.
And I should see you back around 11:15, P.O.
Yes, definitely.
Thank you.
Thanks.
Good morning, sir. What is your name?
Brian Perry.
Okay, give me a moment. I'm going to connect with your PO and you don't have an attorney. So I'm going to connect with your parole officer, okay? Thank you.
Yes, ma'am. All right.
For her. Good morning, PO Gerard. I believe you have to press either *4 or *3 to unmute if you're trying to unmute. There it is. Can you hear me?
Hi, this is P.O. Gerard.
And I have Mr. Perry here. We're going to get started.
All right, perfect.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Brian Perry, 373-781. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Perry, 373781.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your parole officer.
Hi, Parole Officer Gerard.
This is a preliminary hearing which has 3 purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if that act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Perry and P.O. Gerard, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or on penalty of perjury?
I do.
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state Bureau parole officers bring against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney if you cannot afford an attorney. And if you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
Proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state Bureau parole officers bring against you and the information underlying each charge. P.O. Gerard, starting with charge 1, GPS.
All right. Charge number 1, GPS. On January 6th of 25, you signed out of Stein Halfway House at 4:25 p.m. with an approved return time of 11:45 p.m. Your pass was granted for you to travel to your place of employment, Chick-fil-A in West Hartford, Connecticut, at 509 New Park Ave. Upon staff conducting an employment verification check and per your GPS monitoring device, you did not report to work. Therefore, you are unaccountable in the community for 7 hours, 20 minutes. This is in violation of your GPS monitoring agreement that states I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. On January 7th, 25, you signed out of Stein Halfway House at 3:57 p.m. with an approved return time of 11:45 p.m. Your pass was granted for you to travel to your place of employment, Chick-fil-A in West Hartford, Connecticut, at 509 New Park Ave. Upon staff conducting an employment verification check and per your GPS monitoring device, you did not report to work. Therefore, you are unaccountable in the community for 7 hours, 48 minutes. This is in violation of your GPS monitoring agreement that states, I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. On January 9th of 25, you walked out of the Stein Halfway House without authorization. You walked out the door at 1:01 p.m. and did not return to the Stein Halfway House until 3:28 p.m. Therefore, you are unaccountable in the community for 2 hours, 27 minutes. This is in violation of your GPS monitoring agreement that states I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. Charge number 2 is halfway house placement. On December 11th of 24 at 9:57 p.m., you exited the front door of Watkinson Halfway House. A staff member followed you to inquire where you were going, and you responded, y'all called the effing cops, right? And continued out the gate and off the property. Your assigned parole officer made contact with you and instructed you to return back to Watkinson Halfway House. You returned to Watkinson Halfway House on 12/12/24 at 3 p.m. Your whereabouts in the community were unknown for 17 hours and 3 minutes. This is in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On January 9th at 1:01 p.m., you walked out of Stein Halfway House without authorization. Halfway house staff made instructed you that you were not authorized to leave. Your assigned parole officer made contact with you and instructed you to return to Stein Halfway House. You returned to Stein Halfway House on January 9th of 25 at 3:28 p.m. Therefore, you are unaccountable in the community for 2 hours, 27 minutes. This is in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole.
The state has filed the following exhibits, starting with Exhibit A.
Exhibit A, notice of parole violation number 1, which was signed on January 15th of 25. Exhibit B, notice of parolee rights number 1, signed on January 15th of 25. Exhibit C, remand to actual custody order. Exhibit D, PCS signed conditions. Exhibit E, halfway house agreement. Exhibit F, case notes interaction from October 15th of 24. Exhibit G, case notes interaction from November 11th of 24. Exhibit H, case notes interaction from November 13th of 24. Exhibit I, community solutions incident report. Exhibit J, community solutions incident report. Exhibit K, offender misconducts. Exhibit L, offender misconducts. Exhibit M, GPS monitoring agreement. Exhibit N, Stein Halfway House incident report. Exhibit O, offender misconducts. Exhibit P, Allied Universal GPS monitoring report. Exhibit Q, offender misconducts. Exhibit R, Allied Universal GPS monitoring report. Exhibit S, offender misconducts. Exhibit T, Allied Universal GPS monitoring report. Exhibit U, Stein Halfway House discipline report. Exhibit V, Stein Halfway House incident report. Exhibit W, Stein Halfway House discipline report. Exhibit X, Stein Halfway House incident report. Exhibit Y, notice of parole violation number 2, which was signed on January 17th of 25. Exhibit Z, notice of parolee rights number 2, which was signed on January 17th of 25. And Exhibit AA, the parole violation report.
Mr. Perry, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes, ma'am.
And did you have time to review it?
Yes, ma'am.
Today we have no witnesses. And Mr. Perry, it is now your opportunity to respond. Oh, I'm sorry, I'm going to start with P.O. Gerard. P.O. Gerard, at this time, it is now the state's opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations.
Yes, as far as charge number 1 with the GPS, Mr. Perry was had the Allied Universal GPS monitoring device on his ankle, which showed that on the 3 days, January 6th, January 7th, and January 9th, that he was not where he was authorized to be on those dates, and we have the monitoring reports that back that up. And as far as charge number 2 in the halfway house placement, he was at 2 different halfway houses over a 30-day period where he left the halfway house without authorization and was unaccountable in the community.
Thank you. Anything further?
Well, I guess what I would say is that there are case notes, the interactions that are part of the evidence that just show that I think Mr. Perry was having a very difficult time with parole and when with, the conditions of parole and, some of the parameters that were set on him. And I think in some of these cases, his anger had, gotten the best of him and, were a detriment to him, being successful on parole, despite, parole trying their best to get him to have a successful time on parole.
Thank you. Mr. Perry, it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yes, ma'am.
Go ahead.
I agree with Gerard about the anger. A lot of things I didn't really understand. That was like my first time really in a halfway house. So I'm used to dealing with a special parole officer on a one-on-one basis instead of having to wait for certain things. So it's like I didn't understand when they told me about certain restrictions. I didn't understand because when I was in one halfway house, they was allowing me to do certain things. Then when I get to this halfway house, I was supposed to go home, which I felt like when it came to my programs, like CRT, certain things, I don't know if it was I don't know if they got notice of it or whatever. So it was like, I felt like a lot of things was taken from me without explanation. And instead of me really just waiting and sit it out, I allowed my anger to just really get the best of me. You know, I wasn't used to that setting. And I did certain things I did what I felt was best. Like when I walked out, when I was at the Watkinson house, I walked out because I tried to de-escalate the situation the best way I know how, and that was to walk away instead of engaging. And I went to CRT because I knew that it was a program. I had to give a urine, and I just really was kind of confused when she told me that I was under restrictions. It wasn't like really broken down to me how far my restrictions went.
Anything else?
Oh man.
Okay. And P.O. Gerard?
Yes, nothing else.
Okay. On charge 1, GPS, I make a no finding of probable cause on part 3, as the state failed to provide sufficient evidence to prove Mr. Perry's action meets the elements of this charge. I make a finding on the rest of the parts listed in this charge based on state's exhibits D, M, O, P, Q, R, U, and AA. On charge 2, halfway house placement, I make a finding of probable cause based on state's exhibits D, E, I, J, L, S, W, and AA, as well as testimony today. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. So, Mr. Perry, your revocation hearing will be scheduled within the 60 business days since you've come back into custody. You will receive a hearing disposition, which will have a tentative hearing date listed, but please keep in mind that all hearing dates are subject to change. At the revocation hearing, a hearing examiner will determine if you violate the conditions of your parole, and if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanction should be imposed. Okay, so that does conclude your preliminary hearing, and again, you'll receive your hearing disposition with your revocation date, which is again tentative. Okay.
Yes, ma'am.
Any questions?
Oh, ma'am.
You're all set. Thank you, Mr. Perry.
All right, thank you. Yeah, have a good day.
Thank you, Mr.
P.O.
Perry.
Gerard.
Thank you.
Good morning.
How you doing, Miss?
Good. How do you pronounce your last name?
McElroy.
McElroy. Okay, give me 1 second. I'm going to get your attorney as well as your PO on the phone.
Okay.
Thank you. Good morning, P.O. Barrios.
Yes.
P.O. Barrios, it would be, I believe, a *4 to unmute.
Hi, this is Officer Barrios. Hi, this is Officer Barrios.
Good morning. We're going to get started right now.
Okay, perfect.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Chaz McElroy, 345-907. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Chaz McElroy, 345-907.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Hannah Dean for the record on behalf of Mr. Elroy.
As well as your parole officer.
Parole Officer Barrios.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact at each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. McElroy and P.O. Barrios, please raise your right hand. Do solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney, as well as the state, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney, as well as the state, will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review that evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Barrios, please start with charge number 2, notification of arrest.
Okay, give me a minute. Notification of arrest. Okay. On April 12, 2023, a valid non-extraditable warrant for failure to appear, FTA, was issued by the court. You have 48 hours to notify your parole officer of any arrest or offense. You were arrested and charged, and you did not contact your parole officer. You were charged with the following charges: DUI, controlled substance, impaired ability, first offense, trespass by motor vehicle, disregard traffic lane, careless driving. You did not notify your parole officer of the arrest. Based on your behavior, you are in violation of your special parole conditions. Obey all laws. Notification of arrest.
Charge 3, travel.
On April 5th, 2023, you failed to appear for a scheduled preliminary hearing at the Commonwealth of Pennsylvania Court of Common Pleas, 49 Judicial District. You were involved in a motor vehicle accident in Central County, Pennsylvania, and subsequently arrested and charged. You traveled to Pennsylvania in 2023 and you did not request a travel pass. You did not have permission from your parole officer to leave the state of Connecticut. You left the state of Connecticut without prior written permission from your parole officer. Based on your behavior, you are in violation of your special parole condition, travel.
Charge 4, no consumption of alcoholic beverages.
Prior to 4/5/23, you were involved in a motor vehicle accident in Central County, Pennsylvania. You were arrested and charged with DUI, controlling substance, impaired ability, first offense, trespass by motor vehicle, disregard traffic lane, careless driving, docket CP 14 CR 00004562023. Throughout your period on parole, you are prohibited from the consumption of alcohol. Based on your behavior, you are in violation of your special parole conditions, additional conditions, consumption of alcohol beverages. Do you want me to, I'm going to do the other one also, right? Charge 4?
Yep. Yep.
On 4/17/2024, you were alleged to be driving a motor vehicle under the influence of alcohol, resulting in a motor vehicle accident. Farmington PD responded to the area of Farmington Avenue for an OnStar alert of a motor vehicle accident. Upon arrival, officers made contact with you as the operating of a blue Chevy Malibu plate MA5XKE69, as you were confused about your direction of travel and having a strong odor of alcohol emanating from your breath. You were asked to perform a standardized field sobriety test. You failed to perform all the SFST to standards and administered a breath test of 0.1560. Throughout your period of parole, you are prohibited from the consumption of alcohol. You were arrested and charged with operating under the influence, 14227A. Based on your behavior, you are in violation of special parole, additional condition consumptions of alcohol.
The state has filed the following exhibits, starting with Exhibit A.
Conditions of parole. Do you want me to do the exhibits?
Yeah, all exhibits, please.
Okay. Exhibit A, conditions of parole. Exhibit B, remand to custody. Exhibit Z, parole violation report. Exhibit D, notice of parole violation. Exhibit E, Farmington Police Report 24000061119. Exhibit F, letter from Sheriff Brian Samsell, Central County Sheriff Office. Exhibit G, Commonwealth of Pennsylvania, 49th Judicial District, bench warrant failure to appear, page 1. A final revocation in your case has been scheduled for.
Thank you. The state filed an addendum to Exhibit D, which states PCS has requested the withdrawal of the re-imprisonment warrant for Charge 1, obedience to the law, and to only consider Charges 2, notification of arrest, Charge 3, travel, and Charge 4, no consumption of alcoholic beverages. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, we have.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the state's opportunity to present evidence and speak to any of the evidence submitted. P.O. Barrios?
Yes. I'm sorry, what was your question?
Would you like to make a statement regarding the parole charges?
Yes. I would like to just emphasize that Mr. McElroy was very aware of his additional conditions and of his conditions, and he continued to violate, knowing that he already had this Pennsylvania issue. He continued to, use alcohol and drive a vehicle under the influence. He at no point at any time intended to share that information in Pennsylvania or even try to resolve the problem in Pennsylvania, knowing that he had a promise to appear. And he at no time notified me of his travel.
Thank you. Anything further?
Not at this moment.
Okay. And it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Yeah, just some global comments as to the different charges. So the most recent addendum that was referenced, addendum 4, is accurate. For both of the cases that were referenced in the PVR, my client did receive diversionary programs where, if successful, those will result in dismissals of everything. So no convictions at this time. He's looking forward to getting started with the treatment components of those programs ASAP. He's optimistic about earning dismissals in both those matters. I also want to note, just for the second round of exhibits that were submitted on 1/14/25, I just want to note that his signature is missing on a few of those. I just thought that that was worth indicating for the record. But here we're just left with technical violations. So those are my comments as to the charges. And at the appropriate time, I would like to speak to his background and future plans.
Okay, thank you. And
Can I add? Yes, can I add something to what she made her statement on?
Yes.
Okay, so yes, he's been given these programs and he is on probation with Pennsylvania as we speak. And he has to pay some restitution, which they don't see. They're seeing an issue with it, being that he's incarcerated. He's gonna eventually end up in violation with this because he won't be able to take care of his probation in Pennsylvania while being incarcerated or being out. And the missing signatures is because he has to be issued this paperwork for his signature and sent to Pennsylvania that I don't know why he hasn't received and signed. But I have a copy of it that I can submit to him so he can sign and submit to Pennsylvania. But yeah, I spoke with Pennsylvania probation officer, and this is something that he needs to be in compliance with. And he stated that it may be kind of complicated, difficult for him to stay in compliance, being that he is incarcerated and has to pay this restitution and has to report to probation in Pennsylvania and do some other conditions in regards to his probation in Pennsylvania. So this was not something that, like the attorney said, that it was discharged.
Okay, thank you.
If I may just respond, I never made any representations that this was discharged, but this is my understanding. The program he was entered into in Pennsylvania is very similar to the programs that were available here in Connecticut, where the person's monitored by probation, but they aren't necessarily on probation as no conviction has been entered there. So I will just note that if he's successful, my understanding is that that case would go away, much like the result of this in Connecticut. I also just want to make clear that at this point, he hasn't been given an opportunity yet because he is incarcerated to start doing some of that stuff for the program. I don't think it's fair to state at this point that he's going to be unsuccessful in any of that, as he hasn't had an opportunity yet to work on the program while out and make those restitution payments. So I will just, argue that this is he was given the program for this situation for a reason. Clearly, he has a number of things to do in the community once he gets out. However, that isn't one of the charges here. That has been removed, that obedience to the law charge. I just wanted to note that for the record. Thank you.
Thank you. And P.O. Barrios, anything further?
No, not at this moment regarding those charges.
Okay, thank you. And you're also okay.
Yes, thank you.
I'm just going to take a moment before I announce my recommendation or make my findings.
Okay.
On charge 2, notification of arrest, I make a no finding as the state failed to provide sufficient evidence to prove Mr. McElroy's action meet the elements of this charge. On charge 3, I make a finding for charge 3 travel, I make a finding based on state's exhibits A, C, F, G, and H. On charge 4, no consumption of alcoholic beverages, I make a no finding on part 1 as the state failed to provide sufficient evidence to prove Mr. McElroy's action meet the elements of this charge. I do make a finding on the rest of the parts listed in this charge based on state's exhibits A, C, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history. Theo Barrios, would you like to make a statement regarding Mr. McElroy's background and history at this time?
For when I supervised him?
Yeah, programs of participation, his background or his future plans. Is there a statement you
So
want to
I
make?
see, so I see some of the parole accomplishments that the attorney listed for exhibits, the list of exhibits. And she stated some employment with, I had a very difficult time with Mr. McElroy, trying to get confirmation of his employment. He would not submit pay stubs as requested on a weekly and monthly basis. So there was never me able to prove that he was working at those locations for those time periods. Mr. McElroy also was transferred from me from the mental health unit, and was not, had a lot of difficulty with his residence. His mom went back and forth with me a couple of times requesting for him to be removed from the residence because she wasn't able to continue to be responsible for his supervision while on parole. So I just want to put that on the records, please.
Okay, thank you.
Yes, thank you very much. So my client is 37 years old, born and raised in Hartford, Connecticut. Primary source of support is his mother. He also has one son who resides in state here with his mom. Most recently, while on special parole, he was sponsored by his mom, Kim Robinson, in New Britain. Way back in September 2011 to March 2012, he reportedly studied business administration at Sanford Brown Institute College in Farmington, Connecticut. From 2023 to 24, he reports that he attended a barbering program at the Academy di Capelli in East Hartford and had completed 6 months out of that 9-month program. He reportedly utilized various tip agencies for placement, including Staffing Solutions, Accurate Personnel. He also reports employment at NRL located in East Windsor. That was through a tip agency as well. He reports being there for approximately 6 months. Prior to being remanded, he also reports he was at Home Depot in Holyoke, Mass. And that was up until the week prior to remand. I think that was a previous job before while on supervision. In March 2019, when he was on supervision, he did do an intake at Rushford and Middletown and reports that there wasn't any treatment recommendation from there. And then in July of that same year, he did an intake at CRT. He previously was at the Eddy Center and reports while there, he had volunteered at a food pantry in Middletown for about a month and a half until he got an actual job. He was on a minimum contract schedule and was employed in the kitchen upon remand, so he's been working while incarcerated. From reviewing his prior DIF summary, it appears that there haven't been any disciplinary reports since way back in 2011, so he is doing very well, not picking up any tickets. Upon reinstatement of his special parole, he's open to being placed at a halfway house in Hartford. He would prefer open hearth or Watkinson House if beds are available at either of those. He's also hoping to return to that barbering program at the Academy di Capelli. He's got about 3 months left until he's completing that. And then he's hoping, and as well in the meantime, to utilize a temp agency. He also eventually wants to go back to school, do a tractor training certificate to obtain a CDL. And he's open to any sort of treatment recommendations. And then also he'll be doing the treatment that's required for these diversionary programs. I know as far as Connecticut goes, that typically includes anywhere from 12 or more substance use or alcohol classes. So I think that he will be in treatment by virtue of that. He also has every incentive to get back to work in order to make those restitution payments. So he's going to be very busy once he's back in the community, but I believe that he will do well since he will have, some additional supervision by way of those programs. He's been incarcerated on this matter since April of 2024, so he's effectively served over 9 months already on this violation. This is the first violation, I believe, on this period of supervision. It sounds like he's been out since 2022, and I believe that the penalty he's already served is more than enough. So I would ask that he be provided the soonest possible re-parole date. Thank you very much.
Thank you. P.O. Barrios, anything further?
Well, I understand that she feels that he will have a good opportunity to be back in the community, but I don't see this being possible for Mr. McElroy, being that he has our supervision, our programs, and then also Pennsylvania also to be done. And I think he needs to be done an intense mental health evaluation to see if he's going to be supervised by district or mental health unit.
Anything further?
No.
Thank you. Council, anything further?
No, thank you.
Thank you. I'm just gonna take a moment before I make my recommendation.
Mm-hmm.
I have that Mr. McElroy has been on supervision since November 2019. Is that correct, Mr. McElroy? You've been on supervision
Yes.
since 2019 for special parole. You were discharged? Special
Yes.
parole? Okay. And this is not your first violation, correct? This is what I have per our records. This is not your first violation.
Mm-hmm.
And taking all this into account, in these current charges, I recommend revoke and reparole on February 6, 2025, which is an approximate 9.5-month sanction with the following conditions: no consumption of alcohol, halfway house placement, and a mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on February 6, 2025. So on that day, the board's going to take a look at your case. They can agree with my recommendation, which is releasing you that day, which is February 6th, and being that you're on special parole, that will be your release date, February 6th. If the board does not agree, they can impose a sanction longer than what I have recommended, being that you're on special parole until February 2026. If they do recommend a longer sanction than what I've recommended, then another hearing would take place, outlining the specific reasons why they might want to exceed this my recommendation of February 6, 2025. So if you're released on that day, then you know the board agreed. If you're not released on February 6th, that means there's going to be another hearing.
Okay.
All right. And any questions, Mr. McElroy, give me a call at my office, okay?
All right.
All right,
Thank you.
Thank you. You're all set. Thank you, P.O. Barrios.
Okay, that was February 6th or 26th?
February 6th, 2/6/25.
Okay, thank you.
Thank you.
Thank you so much.
Good morning.
Good morning. He'll be down shortly.
Okay, thank you.
This is for McEntyre, correct?
Correct. Yep, thank you.
He's coming down right now. No problem. Yeah, that's the one that's. McEntyre. Yep. McEntyre.
Hey.
And this floor gauge is the ground that you have video for all. You're already logged in. Right there. B.
Good morning, Mr. McEntyre.
Good morning, how you doing? Happy New Year.
Yeah, thank you. We're gonna get started once your attorney's available. He's in another hearing. As soon as he's done, we'll get started.
Okay.
Thank you. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Mark McEntyre, 100822. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in New Haven Correctional Center. Please state your full name and VOC inmate number for the record.
Mark McEntyre, 100822.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney,
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, behalf of Mr. McEntyre this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. McEntyre, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, go ahead.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, absconder. On May 25th, 2024, you left your only approved parole and community service residence, the Sierra Center Halfway House, and never returned. You had no further contact with Sierra Center Halfway House staff or this officer. You left your only parole approved address without program completion and became unaccountable in the community. Subsequently, your whereabouts in the community are unknown. Charge 2, halfway house placement. On May 25th, 2024, you signed out from your approved residence at the Sierra Center Halfway House on an approved community pass for work at 10:19 a.m. with an 11:40 p.m. return time. You failed to contact your parole officer or halfway house staff, and you failed to return to the program by the return time. Your actions violated your signed halfway house agreement. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, signed parole conditions. Exhibit F, signed halfway house agreement. And Exhibit G, Sierra halfway house incident report. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes, regarding charge number 1. Mr. McEntyre, under the absconder charge, it says that May 25th of 2024, you left your approved parole community service residence. Where did you go?
I went to my house, 39 Edward Street, because my mother had dementia. And my brother, who was staying there, we got cameras all over the house. Every time that we look on the camera, he was gone. And, I know I was wrong for, not returning, but I sacrificed my freedom for her safety because, And that's the only reason why I didn't come back. I was still working. I was doing.
I'm going to get to that. I went to your mother's house. How old is your mother?
80 years old.
80. And what town is your mother's house in?
Hamden.
Hamden. Okay. And during this period of time, you were not reporting to your parole officer from May 25th of 2024 on. Were you still working at KFC?
Until July, yes.
Okay. So from May 25th till July, you were working at KFC. What town was KFC in?
Is there, Orange?
Okay. Did anyone from Parole?
No one came by the job or came by the house. And I was like, nobody came by. Yeah, no one showed up.
All right. During May 25th until you were remanded in November, did you ever leave the state of Connecticut?
No.
Okay. So you were at your mother's address and you were still working at KFC during that period of time, right?
Yes.
All right. And were you doing anything else besides working and trying to take care of your mother?
I was going to Olive Street, they got meetings. And at 12 o'clock. And
okay, how often were the meetings?
Every day.
Every day.
12 to 1.
Okay. All right. I don't have any other comments regarding that charges. It's through my client's testimony after speaking to him on telephone. He self-admits he was at his mother's house for the period of time. He was still working at Kentucky Fried Chicken. And he was still going to a meeting from 12 to 1. I know they called the local hospitals and they called the local police stations. Right from my client's testimony, that's where he was because of the issue with his mother.
Thank you. Anything further?
Not at this point.
Okay. I'm just going to take a moment before I announce my findings.
If I may add, it was the New Haven Yale Police, so he was in the area. He said he was all along.
Who gonna win the Super Bowl?
Okay. Charge 1 of the absconder. I make a finding based on state's exhibits B, E, and G, as well as testimony today. On charge 2, halfway house placement, I make a finding based on state's exhibits B, E, F, and G, as well as testimony. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, on behalf of Mr. McEntyre, my client's 60 years old, as indicated, self-admitted as to why he left on May 25th. He told you where he was. He was still working at the time. He's been working at that KFC actually on and off since 2013. So he's been there for a good stretch of time. As he also put on a record, he still attends NA meetings daily on Dwight Street in New Haven. He's currently medication compliant at the facility. Did suffer from diabetes and asthma, and he's had the same medical provider in New Haven for the past 18 years. He does get reinstated, like to be same area, like to be placed in the New Haven area, which is close to his mother. It's indicated to us he can return back to his full-time job at KFC. As I indicated, he's been there on and off since 2013. He's amenable to any treatment recommendation, and he still wants to continue his NA meetings, which he's been doing even while he was not reporting to probation. Thank you. Parole.
Thank you. I'm going to take a moment before I make my recommendation. Okay, Mr. McEntyre, being that this is your second parole violation and the second time you absconded from parole supervision, and your first one also was you committed a crime while your first time absconding, your whereabouts were unknown for about 6 months. And prior to you absconding, you were supervised for about 2 months before taking off from the, before taking off from the halfway house. But taking all that into consideration, I recommend revoke with no new re-parole date, which is an approximate 7.5 month sanction, being that your end of sentence I have here, so I'm gonna pull it up, is July 11th, 2025. So my recommendation is that you go to your complete end of sentence. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, no contact with co-defendants PK, general no contact with Attler Florian, located at 1166 Chapel Street in New Haven, and halfway house placement. My findings and recommendation will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on February 6th, 2025. So on that day, the board's going to take a look at your case, which again is February 6th. They can lower my recommended sanction, and if they do, you would be informed by mail. Or you can contact your attorney as well. Okay.
Call our office on Friday, February 7th. If you can, Mr. McEntyre, after 11, one of the secretaries can let you know over the telephone if they're keeping you until July or if the board reduces it, okay?
Yeah.
All good?
We're all set. Thank you very much.
All right, no problem. Take care.
Good morning, Theo Schaeffer.
Good morning.
We'll get started in about 5 minutes.
Okay, no problem.
P.O. Schaeffer, we're going to get started with Mr. Gura right now.
Okay.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Stephen Gura, 366-876. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office. Counsel?
Yes, Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Gura. I did recently speak to my client. At his request, he is waiving his presence today, and my client wants me to put on a record that he's waiving his revocation hearing today.
And would you like to proceed without your client today present, or would you like for us to have the hearing administratively?
Just administrative hearing is fine by me.
Okay. P.O. Schaeffer, would you like to add anything, or would you like us to receive the report, being that we're going, the client waived, Mr. Gura waived his hearing today?
No, I'm all set. Yeah.
Okay.
Thank you.
Thank you. So this does conclude the revocation hearing regarding Mr. Stephen Gura, 366-876.
Thank you.
Thank you. Thank you.
Thank you. Thank you.
So you should be good to go.
Good morning.
Good morning.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning David Hauser, 430-649. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
David Hauser, 430-649.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello.
Good morning.
As well as your parole officer.
Parole Officer DeVylder, Hartford Parole Special Management Unit.
This is a preliminary hearing, which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Hauser and P.O. DeVylder, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bring against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violations. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. DeVylder, starting with charge 1, restriction of pornography.
Beginning 12/10/2024 through 1/6/2025, you intentionally and purposely viewed sexually stimulating material nearly every day on your monitored electronic device. Per your special condition of parole, you are not to access, view, or possess any pornographic material by any means. Due to the nature of your instant offense, you are prohibited from accessing any pornographic material as it both impedes your rehabilitation and places the community at risk. Charge number 2, enhanced internet and device monitoring. Since your placement at Chrysalis, you purchased, installed, and had been operating a personal Xfinity Wi-Fi wireless gateway and admitted to this on 1/7/2025. You are serving a sentence for a sexual offense where the internet was used in the commission of the crime, which requires you to pay for a software program to monitor all of your devices. At no time were you given permission to obtain this device, nor was this device monitored as required. Charge number 3. Oh, I'm sorry. Part of charge number 2 is still the USB. On 1/7/2025, an unreported, unapproved USB device was found during a search of your residence. At no time are you to have an unreported electronic device. Charge number 3, under problem sexual behavior treatment. A search of your residence conducted on 1/7/2025, you were found to be in possession of an unreported, unapproved Xfinity Wi-Fi wireless gateway and a USB device. Per your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior, you are restricted from accessing any electronic devices. Beginning 12/10/2024 through 1/6/2025, you intentionally and purposely viewed sexually stimulating material nearly every day on your monitored electronic device. Per your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior, you are restricted from possessing any sexually stimulating items and or viewing sexually stimulating material. On 1/1/2025, you were attempting to log into Facebook. You are restricted from the use of social media, and you are purposely and intentionally trying to access the platform. This is a violation of your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior. We also listed the following evidence: A, a remand to custody order; B, PCS conditions; C, the parole violation notice; D, the parole violation report; E, the CTPSB treatment agreement; F, the CTPSB discharge letter; G, the photographs of the unapproved electronic devices to include both the Wi-Fi and USB; H, film description dated 12/29/2024; I, evidence of the search on 12/28/2024; J, IPPC monitoring report excerpts; and K, videos of the cell phone searches.
Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes, I have.
Okay. Today we have no witnesses, and at this time the state will have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations. DeVylder?
No, I really don't have anything to say. I believe that the evidence kind of speaks for itself in regard to all of the charges, especially to include the IPPC monitoring excerpts as well as the video of the internet searches. Thank you.
Thank you. Counsel?
Yes, just briefly. Is it DeVylder? Is that how I pronounce it?
Yes.
Okay. Good morning.
Morning.
The charge 1 states that my client intentionally and purposely viewed sexually stimulating material. And then it goes on. It says you are prohibited from accessing. Did you view my client viewing this sexually stimulating material or accessing any pornographic material? Did you actually witness him doing that?
I witnessed him inputting it onto his phone.
You witnessed him, you saw him enter it onto his phone?
No, I did not.
Okay.
This was on his monitoring software.
Did you witness him, you, viewing sexual material?
Through the IPPC monitoring, yes.
So you were watching while he was watching?
No, sir.
So you didn't view him viewing it. You're just assuming he viewed it because it was on a device, correct?
So the monitoring software monitors.
It's just a yes or no question. Did you
I can
see
answer
him?
a question how I choose to answer the question.
Well, then I'll withdraw the question. Yes or no? Did you view him, as you said, you intentionally and purposely viewed sexually stimulating material? How do you know that?
Yes. Yes.
How do
through the
you know
IPPC
that?
monitoring.
It's him.
Because that is his cell phone. He is responsible for it.
But that doesn't mean that you saw him or witnessed him viewing it, correct?
He inputted whatever he was searching for, sir.
How do you know he was the one that inputted it?
Because
How do you know for certain? You're assuming.
So anyone would reasonably assume that a
Thank you.
phone that is monitored by IPPC monitoring that is registered to him would mean that that individual himself is viewing.
But you have no proof of that.
I have the IPPC monitoring reports that speak for
But you
itself.
yourself said, listen, I'm not trying to get into an argument. I'm just having you admit that you just admitted that you assumed that he did it. That you said any reasonable person would assume that that's
This
what
is
happened.
semantics, sir.
I'm not here to argue with you. I'm just here to ask you a simple question. As to charge 2, where was it found, the USB device?
In a backpack on the floor.
Okay. Do you know whose backpack that was for certain?
Well, he admitted to possessing the USB device, so it would be his.
Okay. And do you know who put it there?
Him.
You're assuming that.
He told me that.
Okay. And it says that he purchased, installed, and had been operating Xfinity wireless gateway. Is that what you're saying regarding charge 2?
Correct.
Okay. And then in charge 3, problem sexual behavior, you said beginning 12/10 through 1/6, you, meaning my client, intentionally and purposely viewed sexually stimulating material. That's the same allegation there is in the restriction on pornography. That's also an assumption, correct?
Per the signed CTPSB agreement, Mr. Hauser is to register and have any electronic device monitored by this software.
Correct.
This monitoring software is evident that this is what Mr. Hauser is looking at through both the excerpts from the phone and through the internet search when I did take possession of the phone.
That's actually incorrect statement because it doesn't monitor who is viewing it. It monitors that it's being viewed.
So
Correct.
you're alleging that Mr. Hauser allowed someone else to use his phone on a monitoring software and purposely viewed at exactly what he is accused of looking at is mirroring his previous offenses.
No, I'm actually not alleging anything. I'm actually stating as a fact that you can't prove who was looking at that. Correct?
He would have to be giving his phone to other people, and why would that be the case?
Well, it could be the case, correct?
No. It doesn't feasibly make sense.
Honestly, this don't make sense.
He is responsible for that phone. Him and only him. He pays $45 a month to have that phone monitored. Do you think he would just allow somebody to go use it?
There's no question posed to you right now. The question is, what proof that you have do you have of your allegations?
The
What proof do you
IPPC
have? I'm not done
monitoring
with my
excerpts.
question. I'm not done with my question. What proof do you have that my client intentionally and purposely, and this is a verb, viewed sexually stimulating material. You have no proof that he did that in charge 1 or charge 3. And more also, you have no proof that it's sexually stimulating material. That's an assumption and a conclusion. And you have also no proof that it's pornographic. There's absolutely no allegation here or proof as to why you're concluding that this is sexually stimulating material. To whom, to where, by what standards, by what definition, and also by what definition are you claiming this is pornographic material?
So first of all, to address your first part of that question, the proof that I have is specifically, again, not to beat a dead horse, is the IPPC monitoring excerpts, the reports from what he's doing, what he's inputting, and as you're questioning as what is pornographic material,
Well, you have to define that.
let's go through the pages, sir. So let's refer to page 6 and 7 where he is researching.
Of what item? What item?
Please stop interrupting me.
What item is she referring to?
6 and 7, you said?
Correct.
Of what?
You refer.
No, their pages are numbered.
Of what? But she didn't say what document.
But the
Parole
pages
Of what
violation
document?
evidence.
Of which document?
The parole violation evidence, sir.
Which document?
So it's literally a page number 6.
I don't have page numbers.
No, keep flipping.
Why
Which
don't you look
exhibit?
further
Which
into
exhibit are we
evidence?
talking about? Which exhibit? There are multiple pages of multiple exhibits. All I'm asking is which exhibit are you talking
Page 6
about? Of which exhibit?
of the parole violation evidence, sir.
No, we don't. These are separated into
They're not
exhibits A. Yes, they are. A, B, C, D. You listed them out that way. Which exhibit are you referring to? Well, this is a hearing here.
Let her give you the, she's going to give you the,
Which exhibit?
you're looking for the exhibit, correct?
I want to just say one thing first, and then we could talk about the exhibit. So when you're looking at his PCS conditions as part of exhibit, I'm sorry, B, under enhanced internet and device monitoring, this explains it all. You understand that you are responsible for all materials and information on any of your electronic devices. So no matter what, that is the phone attributed to Mr. Hauser, and he is responsible for all material and information on that device.
There's no proof he viewed it.
Excuse me?
There's still no proof he viewed it. And there's still no
He
proof
is
that it's
responsible for
But
it.
there's no proof it's pornographic, and there's no proof it's sexually stimulating. You've offered no evidence that it's sexually stimulating, and you've offered absolutely no evidence that what is on the phone is pornographic. Those are conclusory assumptions that you're making. Where is the evidence that those are sexually stimulating, and where is the evidence that it's pornographic? Thank you.
Field DeVylder, do you have any remarks regarding those specific questions? Field DeVylder, do you need a moment? You're muted. Okay.
I apologize. So where was the last part that you heard me? I apologize.
I didn't hear anything. You
Did you
were
hear
muted.
me? Okay. So
So my question to you was, do you have any specific remarks regarding any of the questions Attorney Famiglietti had asked you?
Yeah.
Because if not, okay, go ahead.
I would like to refer to Exhibit I, which is page 6. It's the description of the search that Mr. Hauser had made on 12/28/2024. It is a virtual reality movie regarding stepfather-stepdaughter incest. I can go on to give a description of the video. My beloved daughter shows her underwear, chest, buttocks, etc. to her dad. Daddy, are you getting bigger? Carefully lift your dad's dick and make you squid. In addition, the temptation of the daughter escalate to straddle herself for incest sex. My father and daughter have had vaginal gunshot with forbidden dense sex. I would consider that to be quite pornographic and mature content. To move forward, I'm still speaking. I'm still speaking.
Okay.
We can also refer to page 8, which is pornographic.
By what definition?
By the base, it's erotic content. Page 10. Someone straddling a gentleman. I can't tell if it's a child or not.
It's not part of it.
Page 12. A woman laying in bed moaning. Page 32 and 34.
You have this?
It's black and white, but it's in color. She submitted it in color. You printed off. It's
I
printed
don't know
off.
what she's reading.
She's page.
I was on page 10 right here. Page 10.
Mhm.
There's no writing on page 10.
So she was referring to the picture. That's how for page 10. And then you went on to page 12, correct?
Right, but that's not it.
Correct.
That's her
Page 12,
interpretation.
page 32. We have both page 39 and 46 indicating oral sex. These are not rated R movies. These are films that are pornographic and sexually stimulating material.
By what definition?
Exactly what I said, sir.
So she can.
Peel DeVylder, anything further?
No.
Okay, thank you.
So my conclusion or my argument is that it doesn't matter what the witness thinks of these things. The witness has a duty and a burden to prove the allegations. And the allegation in charges 1 and charge 3 specifically allege that my client and you intentionally and purposely viewed these. All I'm arguing is regardless of what's in this huge packet, there's no proof that he viewed it. Okay, even if they say he had these documents, no one witnessed him viewing them. And that's what they're alleging. You can't allege something based on assumption. And you also can't assume because one person says this is sexually stimulating or that one person makes a conclusion. Those words have meanings. Those words have definitions. Makes a conclusion that they believe it's pornographic does not mean it's pornographic. There's no standard. There's no definition offered. It's just her opinion. And I don't believe that carries. I don't believe that is probable cause or proof to the standard because there is no standard set. It's whatever she thinks it is, whatever the parole officer thinks it is. And I don't believe that is legal. I don't believe that meets any standard of evidence. And I don't believe that meets any legal standard as to those allegations that my client viewed or accessed anything.
Thank you.
And I certainly don't think that these allegations are sufficiently serious enough to go forward with another hearing. My client's been incarcerated since January 7th. There's no proof that he accessed any of this. Merely because it's on a device that he may say is his doesn't prove that he's accessed any of this. Doesn't prove that he input onto the device. We can make assumptions that happened, but we can't assume in the legal world. Thank you.
Thank you. And Peel DeVylder, I just want to give you one more opportunity to respond.
Yeah, I just want to reiterate that the Board of Pardons and Parole does set that enhanced internet and device monitoring stipulation for specific high-risk sex offenders, which Mr. Hauser does fall under that category. He is responsible for all materials and information on any of that electronic device. I will tell you by the amount of pages in this evidence that obviously there is a significant amount of very questionable material for a registered sex offender to be viewing. Mr. Hauser has only been in the community for a month and a half, and he had gone to inpatient treatment, and it's still apparent that he doesn't see anything wrong with what he's looking at here, which is extremely concerning due to his sexual deviancy. This behavior increases his risk to reoffend. You know, the content of the information that he's viewing based on his previous convictions. And I do want to just ask you real quick, Attorney Famiglietti, would you consider a stepfather incest video
Objection,
to be?
relevance. My opinion doesn't matter.
Oh, okay, but that's interesting. Thank you. I'm all set.
So, and
Just briefly. It's not my burden of proof. It's my job to hold the state to its burden of proof. Material was just described as questionable material and content. There are levels, there are definitions, there are standards. And merely because he possesses something, I'm not arguing that he didn't, that his phone did not possess it, or the phone did not possess it. The allegations are that he viewed it and accessed it. That's what I'm challenging, because there's no proof of that. There are assumptions.
anything further that wasn't already said, P.O. DeVylder?
No, I'm good. Thank you.
Okay, and anything further?
No.
That wasn't already said. Okay, thank you. I'm just gonna take a moment before I announce my findings. On charge 1, restriction on pornography, I make a finding of probable cause based on state's exhibits B, D, and J. On charge 2, enhanced internet and device monitoring, I make a finding of probable cause based on state's exhibits B and D. On charge 3, found sexual behavior treatment, I make a finding of probable cause based on state's exhibits B, D, E, and J. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. Mr. Hauser, your revocation hearing will be scheduled within 60 business days from your return to custody. You will receive a hearing disposition from today, and is going to have a tentative hearing date listed for your revocation hearing. Keep in mind that that date is a tentative date, so it can change. But again, your hearing has to be scheduled within 60 business days. And at that revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. Okay, so this does conclude your preliminary hearing. Do you have any questions about what just occurred in terms of what's the next steps?
So I remain here.
Yes. So you're going to remain there, and they'll schedule a hearing within 60 business days of your remand, sir. Okay? Call me if you have any questions. Call me if you have any questions. And the next hearing is a higher standard of proof. Okay?
Okay.
All right. Take care, sir. Have a good day.
Yeah, thank you. Thank you for your
All
time.
set. Thank you, P.O. DeVylder.
Thank you so much. Bye-bye.
Inmate Tyler Singewald hearing is canceled, being that he waived his preliminary hearing. Therefore, this case is for today.
this was gonna happen today.
Okay.
And then I don't know.
Spoken. You right there, so it's like FaceTiming, the judge or parole, whoever. So you could let her know that you waive that changes anything. Hey, quick question for you. So he's saying that he waived it. I don't know if that makes any difference.
I never been through this, so I don't know what to do. I have no
So
clue.
chat with her, just see what she
We'll do,
says.
so I don't have the paperwork that you did waive this, but we can do it on the record. We just have to wait until we go on the record, okay?
Oh, I
Yeah,
don't know.
we'll handle it.
I've never been through. It's my first time. I've never been through this. I don't know what's going on.
So she's just saying she doesn't have the
Absolutely.
documentation.
Okay, that's all right. It's all right.
And if you still wanna waive it, she's saying you can, she just needs it to be officially stated on the record.
On the record.
Meaning like.
Yeah.
recorded. Okay?
Yep.
All right.
So just
I'm here.
give me a moment, Mr. Rivera, we'll get started in just a second. I do need to record it, okay? So,
Okay.
good morning. I am Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jose Rivera, inmate number 244121. Today is Monday, January 27, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Jose O. Rivera, 244121. Date of birth, 8/16/79.
Oh, okay, thank you. So this is a public hearing. Public has access to this hearing, and the hearing is available via video live stream. So I have listened to what you were just saying, Mr. Rivera. You're requesting to waive this hearing?
I've never been through this, so I don't know what's the process. I've been home. I did 4 years in Osborn, 2 years out there. I did my I graduated from Workforce Islands. I did my next day program. At the end of the month, we'll start saying Wayfield with Glenn Young.
Yes,
So I don't really know
this is
what's the process.
what's going on. This is a preliminary hearing. So basically, we're establishing probable cause to determine whether or not you should proceed to a revocation hearing for your parole. So you do have rights at hearing. You did not request an attorney. Would you like to move forward with an attorney at this hearing? If you waive this hearing, what would happen is whenever your pending charge is complete in the courthouse, you would then be scheduled for a revocation hearing. Or we can move forward today, just you and I.
Because I got caught at third. And the third I got
So
caught.
again, this is 100% your decision, but those are the options. So we can move forward today, and I can determine whether or not probable cause is met with your violation. You can waive today's hearing on the record, and I'll just confirm if that's the way you want to go. Or we can continue the case for you to have an attorney for today's hearing.
What would you think I should do? Because it's my first time on parole. I've never been through this little. I have no clue. What should I do?
I mean, I can't give you legal advice, unfortunately. So waiving the hearing means that you're just conceding to the probable cause standard. So that means you're waiving your right to an attorney. You're waiving your right to respond to the violation notice. You're waiving your right to have today's hearing to establish probable cause. What that means is that once your case is disposed of in the courthouse, then you'll come back for a revocation hearing.
Okay.
So you are waiving a few rights if you waive today.
Yeah. So what's going to happen? What's going to happen?
So if you waive, you just wait until your case is disposed of in court, and then your parole officer in the community will let us know that it's done, you completed it, and that will bring you back in to do the revocation process.
Because I got 2 years to EOS, and I got 640-day jail credit.
Correct, but you also have pending charges. So those also have to be addressed in court. So if you wanted to move forward today, my advice to you would be that you are pending a court case. So you do have the right to remain silent during this hearing as well. But
But you do have the right to move forward with today's hearing if you want to go through the motion of it, or you have the right to waive it if you concede to the probable cause, and that we'll wait until your case is disposed of in court to bring you back in for the revocation.
Yeah. I
So
went
did
to my
you wanna
court
move
case
forward?
over there. Because I wrote
Okay.
to waive the parole. I wrote like last week I wrote to waive the parole.
Okay. To waive the preliminary hearing?
Yeah.
Okay, so then I'm just gonna go over your rights with you, and just so you're aware of what you're waiving at this point, okay? So you are waiving the right to be represented by an attorney at this hearing. You're also waiving your right to receive the notice of the charges of violation. You're waiving the right to review the evidence against you before the hearing, and you're waiving the right to submit evidence in support of today's hearing. As we discussed, if you waive today's hearing, your case will just be pending with us until your court case is concluded. Once your court case is finished, we'll bring you back in to do the revocation process. Are you willing to still waive your right to today's hearing, Mr. Rivera?
Yes.
Okay, so I am now going off the record. This does conclude the preliminary hearing for Jose Rivera, inmate number 244121, as he has waived the right to his preliminary hearing, conceding to probable cause. And I am also finding the fact that there is probable cause and the acts are serious enough to warrant revocation. And as discussed with Mr. Rivera, his revocation hearing will be scheduled upon his conclusion of his pending court case. Okay, you're all set, Mr. Rivera. Thank you for talking to me today, and I'll see you soon. If you said your court hearing is in a week or two, hopefully it's concluded. The third, so next week, I think. So hopefully it's
because I told him
concluded.
I told him run my because I had 3 minutes, I told him run it together and get it out the way. I told him.
Yeah, so whatever happens, we'll be notified by Parole and Community Services, and then we'll bring you back in for the revocation hearing. Mr. Rivera, at that revocation hearing, are you interested in an attorney?
No, I got an attorney.
You have a private attorney?
Yeah, I got
So just
his name right here. Lord,
Just
I
make sure
got
they file.
Lord Romano, that's my lawyer.
Okay, make sure
That's
they
my
file an
lawyer.
appearance with us. Yeah, they have to file an appearance with Parole if you want them to represent you at your revocation hearing, okay?
All right.
All right, so you're
Okay.
all set, Mr. Vera. And like I said, we'll see you as soon as your officer sends us the conclusion of your court case, okay?
Okay. Thank you for your
All right,
time. I
take
appreciate
care.
it.
No
too.
problem. You're all set. Have a good day.
Thank you.
No, thank you. Good morning, Officer Kwasnik. How are you?
Good morning. Good, you?
Good morning. Great. Mr. Plevka's attorney is in another hearing, so once they're concluded, he'll be popping over.
No problem.
Hello.
I'm here. I'm just listening.
All right, sounds good. Hello.
Thanks.
So for Plevka, we're still on standby?
Yeah, if you want him in the chair, he can sit in it, but yeah, I'm still waiting for his attorney.
Okay, well, I have him sitting right here. Whenever you guys are
Oh,
ready.
that's whatever. Okay, sounds good. I'll let you
Whenever
know
you're
as soon as
outside.
he walks in.
I got you. All
Great,
right.
thank you.
You're welcome.
If you want, I can do one of these. So like I will rewrite the same information, you sign both, you have a copy, I guess. That way you know. I do, all the time, all the time, right there. That way you would take one. What was that? Oh, okay. That's good though. Now you gotta go to the tech, that's why we standing here? Yeah, okay.
I got some cards, I got you, but my brother, no, we're missing
And let this be a stepping stone to get back out there and get right.
arguing with wife, we didn't want to let me out.
Yeah, so then you don't want to. I get it, they go around it. Okay, good luck with everything, right? Oh, Erik, that, Erik, here, coming in my phone.
Right. Right. Keep off your car, you really want you to jam up.
Watched the game last night. Yeah, the whole thing.
Good to see you. Officer, can you hear me?
Yeah.
Awesome. Perfect.
Good to go?
Thank you. Yeah, we're ready to go. Thank you.
Yes, ma'am. Right over here.
Officer Kwasnik, are you ready to proceed?
Yeah, I'm all set.
Perfect. So good morning, I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Erik Plevka, inmate number 314771. Today is Monday, January 27th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Erik Ryan Plevka, 314771.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti and Parole Officer Kwasnik. Attorney Famiglietti, can you identify yourself for the record, please?
Certainly. Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, Mr. Plevka. Hello,
How you doing,
Fiona. Good. How are you?
I'm
Good morning, Fiona.
Good. Officer Kwasnik, can you please identify yourself for the record?
Sure. Dennis Kwasnik, Parole Officer 2, State of Connecticut.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Mr. Plevka and Officer Kwasnik, can you both please raise your right hands? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
I do.
Thank you. So we're going to go through the procedure for the hearing. The first is I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering the evidence presented, I will announce my findings, and if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history, and then once the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over the rights that you have for this hearing. The first right is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
Great. You also have the right to review the evidence that has been brought against you before this hearing. You have the right to submit the evidence in support of your case, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the underlying information for each charge. So Officer Kwasnik, can you please read the charges that you have brought against Mr. Plevka?
Sure. Charge number 1, condition is obedience to the law. The violation details are on September 6, 2024 at 7:33 p.m. You were stopped by the Torrington Police for operating a motor vehicle with an upside-down license plate. During the traffic stop, it was determined that your driver's license was suspended. As a result of your actions, you were issued a summons for operating under suspension and failure to display plates. Charge number 2 is general no contact with the victim. Violation details are since December 8th, 2023, you have had contact with Amanda Schaeffer in violation of your strict no contact parole stipulation. Charge number 3 is no driving. Violation details are on September 6, 2024. You were observed by the Torrington Police operating a motor vehicle. You did not have my permission to operate the motor vehicle.
Thank you. The state has also filed the following exhibits that have been marked for identification purposes. Officer Clausen, can you please identify the exhibits you've submitted?
Sure. All right. I have Exhibit A, signed special parole conditions. Exhibit B, remand to custody. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, explore progress report. Exhibit F, emails from Community Solutions. Exhibit G, Torrington Police Report 24-29291. Exhibit H, DOC Security Division phone documents. Exhibit I, printout of judicial website of docket L18W MV24 0278239-S. That's it.
Thank you. But you also did submit an addendum on January 10th, 2025. Is that correct?
Yes.
Can you please read the addendum you submitted?
Yep. On January 9th, 2025, Mr. Plevka appeared at GA 18 under docket L18W MV24-0278239-S and pleaded guilty to 14-215A, legal operation of a motor vehicle while under suspension. Mr. Plevka was subsequently sentenced to 30 days in jail for his actions. The accompanying charge of failure to display number plates 14-18A subsection 1 was nollied. This time there are no pending criminal cases and his revocation can move forward.
Thank you. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we are.
Great. I also did receive an exhibit from the defense as well. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Is that correct?
Yes.
Great. Do you need any additional time to submit other evidence?
No, we do not.
Okay, so today we do not have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. Officer Kwasnik, would you like to make a statement?
Sure. Just to summarize why Mr. Plevka is in front of us today is basically his contact with his victim, which is his girlfriend. And if we could review his history, it started on January 19th, 2022, when the Winchester police responded to a domestic call involving the victim and Mr. Plevka. The victim reported that Mr. Plevka assaulted her in the car and they left the scene. Police stopped Mr. Plevka and observed the victim yelling for help inside the car. Upon further investigation, they discovered that Mr. Plevka punched the victim several times and thrown her head into the center console of the dashboard of the car. The victim was covered in blood and pleaded with the police to arrest Mr. Plevka. He was subsequently violated for those actions and was reinstated. When he was reinstated, he was also violated again 6 days after his parole was special parole was reinstated. He violated his parole conditions numerous times by contacting Schaeffer, going to her residence, violating his curfew, and failing to charge his GPS device. Misconducts were issued in an attempt to correct his behavior and to keep him into the community and try to control his behavior in the community. However,
Officer Kwasnik, anything, can you just focus on the charges brought today, and then that can be more for his history?
okay, I just thought it was
read the
relevant because this is.
I read the PBR submitted, yeah, absolutely, but
okay, just put on the record that this is the third violation of contact with the victim, and the history is violent in nature. So when he was reinstated for this violation on December 8th, 2023, A case management plan was developed to focus on his substance abuse and as well as his contact with the victim. Within a week of being reinstated, he had contact with his victim again. Investigation determined that Mr. Plevka had sent threatening messages to a male that was speaking with the girlfriend / victim, which resulted in criminal summons for harassment in the 2nd degree. Just want to make note that I issued a misconduct, kept him out into the community. Despite the aforementioned arrest for threatening, again, he was placed on GPS monitoring, and he was also told not to have contact with the victim. He said that he ended the relationship with the victim. I didn't have to worry about that anymore, and he would not have any contact. When he was pulled over for the license, driving without a license, I also kept him out in the community. However, when I discovered that he had contact still with the victim who was currently incarcerated at the time, a remand was filed. As the evidence will show, Mr. Plevka sent over 4,700 messages and over 1,300 phone calls to the victim. A sample of the evidence of the that you have, which I think are over 1,000 pages, clearly show just a cycle of violence, a pattern of violence. You'll have like a honeymoon phase where he's apologizing to the victim, and then all of a sudden he's threatening her, or he's claiming that she's having sexual relationships with other inmates and staff in the prison, and it's just a really volatile relationship. So that's why he was remanded, and really that's my main concern right now is his substance abuse and the contact with the victim based on his history.
Yeah. Counsel, it is now your opportunity to call any witnesses, present evidence, and speak to the charges.
He's not charged at all with any substance abuse issue, so that's relevant. But I've got no comment regarding the preponderance standard regarding any of these 3 charges. The first and the third are him driving when he shouldn't have been, and the second I'll address in my comments later.
Thank you.
But I've got no comment as to preponderance. They clearly had contact.
Thank you. I do appreciate your comment. So I am just going to take a moment and I'll let you know my finding. So for charge number 1, I do find that you violated the condition of obedience to the law based on your conviction under Connecticut General Statute 14-215A, the illegal operation of a motor vehicle under suspension. And your conviction was on January 9th, 2025, when you were sentenced to 30 days in jail. In addition, the following evidence supports the charge. I have Exhibit A, C, G, and I. On charge number 2, I'm finding that you also violated the condition of a general no contact based on the evidence provided in support of the charge, which is Exhibit A, C, E, and F. And on charge number 3, the no driving, I am finding that you violated the condition based on the evidence provided in Exhibits A, C, G, and I. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, the state will have the opportunity to speak more to your background and history, and then after the state is finished, you and your attorney will have the same opportunity. So the purpose of this part of the revocation is to help determine what outcome I will recommend. So Officer Kwasnick, any additional information that has not already been submitted or stated?
Just going back to what I was initially stating, Mr. Plevka does have a history with the victim as my main concern. The prior 2 violations both involved violence with the victim. He has made statements to me that there's nothing that parole could say or that he'll do, that he's still going to have contact with the victim, that he loves her. I don't know how to control that behavior or to enforce that board's conditions with his attitude. My recommendation was due to this complex nature of his relationship with the victim, the ongoing risk that he poses with her, that, I mean, this really should be reviewed at a full panel. I don't feel comfortable making a recommendation for him to have contact or not. There's a history of abuse. I mean, the victim has reported to me, has reported to the police, a severe history of abuse by Plevka in the relationship. His messages to the victim while she was incarcerated show a clear pattern of a cycle of abuse or a battered women syndrome. In regards to his history, again, he has a history of domestic violence and non-compliance with parole. With the substance abuse, he admitted to me that he was abusing his Adderall that as a, I don't want to say an excuse for his behavior, but he was doing well with, as far as I know, with alcohol and drug abuse. So when we were focusing on the case management plan to address his behavior, he was doing a good job with the substance abuse besides the Adderall, which was legally prescribed, which I found out after the fact. With his toxic relationship, he said that he was married to the victim. In the evidence that he submitted, or the defense submitted, it says that they're not married. So there's no children. There's no, as far as I know, houses that they share or assets that they share. So this is not as complex as it could have been if they were married or share children. But again, with the toxic relationship, therapists see this, they've advised him against it, his parents are against it, the courts see it, I see it. We've had numerous conversations that this is just a toxic relationship. He's going to end up getting in trouble or relapsing if he has contact with the victim. So that high risk to of renewed conflict, the victim's history of substance abuse, too, her past violations of protective orders, their history together of excessive alcohol use. They were saying that they were drinking a gallon of vodka today or a day, and it would just result in violence between the two of them. He obviously has anger issues, which we have been addressing. Recent comments in therapy and emails also suggest he has an ongoing anger issues that still need to be resolved. Statements were made when I was remanding that he would have fought us in the past. He has fought us in the past when we were remanding him. And so, again, I think they should go to full panel. I'm uncomfortable making a recommendation of how long he should serve incarcerated, but if he is reinstated and he is allowed to have contact, I would recommend that he has mandatory participation in Explore. He was participating. He was doing a good job with that, and the R&R program for driving without a license. He was engaged with that. I would also like to see an anger management program stipulated. If the board places restrictions on contact with the victim, if it's conditional contact, again, I would feel more comfortable having the Explore program recommend that he have contact with the victim, and I think maybe mandatory couples counseling if contact is allowed, just due to this history, this toxic relationship they have, this history of domestic violence. And if no contact is stipulated by the parole board, if they want a strict no contact and they deem that their contact is too risky, I think I'd just place him on GPS and make a return of first sign upon contact with the victim just based on his past behavior.
Thank you. I do appreciate your statement. Counsel, is now your opportunity.
Yes. So I think the number 10 is there's a theme with the number 10 here. So my client and the alleged, I'm not even going to call her the alleged victim, because the incident that the PREO referred to happened over 3 years ago. There haven't been any arrests or incidents between them that have called the police into call in 3 years. My client is 40 years of age. I spoke myself on the telephone with the alleged victim, AS, on the 17th and the 23rd of January. She absolutely wants contact with the defendant. Both my client and the victim, if you want to call her a victim, she's an adult. There are no protective orders. There are no restraining orders. There's just this order that they can't have contact. They've been together, here's the first 10, for 10 years. They're not married. She's not just his girlfriend, she's his fiancée. They intend to be together. This parole ends in 2027. So there's going to come a point in time when they're together. His parole wasn't violated. He wasn't remanded until September 27th. They had contact for 10 months and there had been no arrests. They had had contact for 10 months. The whole time. Yet he wasn't remanded until he was driving under suspension, and he served that time. So we have him driving when he shouldn't have driven and gotten arrested and done 30 days for operating under suspension, a nonviolent crime. And then just having contact. He's not charged with threat. He's not charged with breach of peace. He's not charged with violating a protective order. They both have been having contact. They both want contact. So it begs the question, should there even be a no contact order between the two of them? He did violate, but the result of violating a no contact order isn't to throw someone in jail. He's not on, he disposed of his case that put him on his parole 8 years ago. He had one case with her 3 years ago. My client obtained his GED online over the summer of 2024. That's commendable. He wants to, he was due to begin the auto mechanics program at Porter and Chester Institute. He had been tattooing out of his grandfather's residence. He worked part-time at Sasso's Coal-Fired Pizza. In March to October of 21, he worked at ZT Construction. I think what's noteworthy is if he needs anger management treatment, even though there are no incidents here of any violence, and if he needs Explore, it is the most thorough domestic violence, anti-anger management, conflict resolution program we have. And I ask you to look at Exhibit E, which is the report from the Explore process report. 9-4 present participation fair. He has 2 fairs, but all of his other participations are good. 9-4, 24, 8-28, 8-21, 8-14, 8-7, 7-31, 7-17, 7-10, 7-3, 8. It just goes on, and I'll hand it to you so you can say you have it now. Participation, good. And only 3 unexcused absences in quite some time, from April to September. He was present 18 times. What more can we ask of him? He's doing the Explore program. He has a job. They're not married, but they have the paperwork to go and get married. I spoke with her. They just haven't been able to do it because she's incarcerated or he's incarcerated. These 2 people are going to be together. He's not charged with a crime related to her conduct. It's just a condition of parole, and he violated. But not every violation of a condition of parole requires someone to be warehoused in jail. Just because there's a protective order, there's no protective. But just because there's an order of parole and he violates it, doesn't mean, oh, we're going to throw him in jail now. Let's hold him in jail. He's been in jail. He's been in jail now since he was remanded on September 27th, excuse me. We don't have any allegations that he's contacted her since then. Maybe he got the message. So I don't think that incarcerating my client further when he has apparently gotten the message. We know she still wants to contact him. The second question, whenever we face a violation or a crime, when I was a public defender for 28 years in court, the first question is, has he violated? Is there a crime broken here? And if the answer is yes, the second question is, well, so what? So what? Just because you break the law doesn't mean you go to jail. Just because you violate a condition of your parole doesn't mean you have a long sanction. Thank you.
Thank you. Just gonna take a moment and I'll let you know my recommendation.
Take your findings.
I did.
I saw 3, right?
Yeah. Great, so I have listened to the testimony today and I've reviewed the evidence provided. Based on that, I am going to recommend your parole be revoked and that you serve an approximate 7-month sanction period of confinement, and that's with a re-parole date of April 29th, 2025. In addition to that recommendation, I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with the co-defendant Justin Lee Montaigne, general no contact with JD and AS, mental health treatment, and no operation of a motor vehicle without parole officer's permission. I do have a sponsor. Is that correct, counsel?
Yes, he wishes to be sponsored. One moment.
Ms.
His
Suma.
grandfather,
Yes.
Dennis Suma.
That's his, Mr. Suma, that's
Yes.
his grandfather. Okay.
Thank you.
Okay, so happy house. So my recommendation is going to go to the board on February 6th, 2025. And you'll receive a written notice, a final decision from them shortly after that date. At that hearing, the board can lessen my recommended sanction. They can let it stand, or they can impose the sanction longer than what I've recommended. If they do choose to impose a sanction longer, you'll be notified, Mr. Plevka, because they'll have a supplemental hearing and they'll want you to be present to address their concerns with them, okay? Do you have any questions at this time? Any questions?
No, I'm good.
Just briefly, Mr. Plevka, if you have contact, they're going to violate your parole.
Yep.
So if you wish to have contact with her, what you need to do is talk with your parole officer and go through the appropriate channels. You have no right to argue that you're in jail if by having contact. You understand that there's a clear no contact order, right?
Yes, sir.
You've got to go about things the appropriate way. Okay?
Yeah.
They're trying to act in your best interest. That's their job. Okay?
I know. I understand.
This isn't a conversation or a debate. I'm just telling you, as your attorney, there's appropriate ways of going about things.
I know.
Okay.
All right.
So this does conclude the hearing for Erik Plevka, inmate number 314771. You're all set, Mr. Plevka.
Thank you very much, ma'am.
Have a good day.
Thank you,
Thank you,
Mr.
Officer
Plevka.
Kwasnick.
All right, Eric, we'll see you in a couple months.
Yep.
All right, thanks.
Good morning, Officer Huff. Are you with us?
Morning, yes, I am.
Perfect. So I'm going to try to do Mr. Figueroa first with you, and hopefully it works out okay.
Okay.
Thank you.
Thank you.
is driving me up the wall. I'm stressed as fuck, my acne.
Good morning, how are you?
I'm well, how are you?
Great, thank you. I think I have two with you guys today. Does that sound right?
Is it Figueroa and Thomas?
Yes, if you don't mind, can you send Figueroa in first, please?
Not at all. Are you ready for them?
Yeah, I'm all set. Thank you.
I've had more therapists on my hands than I can count. I've been in and out of Nashville since a little boy, went to my dad's house. I've been in Yale New Haven Health LV2. I've been in Iowa Living. I've gone to the Joshua Center for an aftercare program. I've gone to Bradley School. I've gone to probably every school in the state. I've gone to ACES. I've gone to probably every special ed school conceivably possible in this state. And I've been either kicked out of everyone or I've moved from place to place and had to go to a different transportation.
Good morning, Mr. Figueroa. How are you?
1 second, let me get this out the way.
Oh, great, thank you.
Yeah, can you still see?
Yeah, that's perfect. Thank you. Good morning, I'm Parole Officer Trussell, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning George Figueroa, inmate number 192694. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and McDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
George Figueroa, 192694.
This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Parole Officer Huff. Officer Huff, can you please identify yourself for the record?
I'm Parole Officer Huff, Hartford Special Management Unit.
Thank you. So before we get started, Mr. Figueroa, I do see you did request an attorney. Is that correct?
Yes.
I have not received an appearance for you. Have you spoken with anybody yet?
No.
I have not. Okay. Are you looking to obtain counsel for this hearing?
Yes.
You are. So would you like a continuance of today's hearing for counsel for the Public Defender's Office to get in contact with you?
Yeah, because I want to be able to. Yes.
You want an attorney? Okay.
Yes.
So just to confirm, I'm just going to repeat it one more time. Today's hearing is a preliminary hearing for George Figueroa, inmate number 192694. You are requesting counsel for this hearing and you would like a continuance to obtain representation, correct?
Right.
Okay, so then I am going to continue today's hearing. I do have another one scheduled next week on the 4th. I think it's Tuesday. So I will schedule you for that hearing date and hopefully by then the Public Defender's Office will be in touch with you, okay?
Would the public defender see me before that? Before
I'm
court?
hoping, did you submit an application yet?
Yes.
You did submit an application? Okay,
Yes.
so I'll have my supervisor maybe follow up with an email to them or I'll try to. That way they can hopefully get in touch with you some point this week, okay?
Okay.
All right, so this does conclude today's matter. As stated, we are going to continue the hearing to Tuesday, February 4th, 2025 for Mr. Figueroa to obtain counsel. Officer Huff, would you like to be present for that hearing?
Yes, please.
Okay, great. All right, so then we are all set. We're going off the record. Thank you, Mr. Figueroa.
Thank you.
Have a good day.
Yes, thank you.
What do you mean by exclusionary zones? I thought
Thank you.
Thank you.
Connecticut. So there might be more than just Woodford.
Finish.
So what if per se, like I had to travel down I-95 to get to another location and it happened to come through that town line, would that be a violation of probation? Okay. I'm gonna be going from Bridgeport to Waterford where my grandma lives. So it's like, I wanna know, so my grandma knows the proper route, so I'm not.
Thank you. Mr. Thomas, correct?
Yes, ma'am.
All right, I just need to locate your attorney and I'll be right with you, okay?
Okay.
Is there gonna be another follow-up meeting or is this one of the last?
And it's gonna get assigned to appeal there. And once you get out, I bet then here.
All right, thank you.
I appreciate your time. I wish you a lot of luck there. We've got a lot of stuff. It's gonna take time. Just take it one day at a time. You know, it's such a PO. And just let them help you get this serious probation expensive. Whatever you need or whatever you have issues and stuff. I tell everybody, especially if it's gonna be a first time on probation. I tell everybody this same thing. You're going to have to go to the PO because you'll be able to get more assistance if you do that.
I appreciate it. Thank you. Have a good day. Go as well. Moving.
I can just keep kind of
What I like, he was shaking and sit around, what he's going, what the fuck is
It's not bad. I need to get out of here.
it? Around, man.
No, good. I actually had those.
Oh, yeah.
We got jail in federal door.
Okay, he should be on his way over, okay?
Yes, Kristen, thank you.
No problem.
But that's my workout.
Not here. Just get room. I was just saying, not contact. This is supposed to. It's so low. Oh, yeah. I agree. Yeah, it's all. Oh, I know. I just trying to build a person. Oh, yeah.
Okay, good morning. I'm Parole Officer Tricello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Timothy Thomas, inmate number 405-566. Today is Monday, January 27, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and McDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, my name's Timothy Thomas, inmate number 405566.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Thomas.
This is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath, so Mr. Thomas, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. I'll then review and identify the exhibits filed for the record. The state is not present at today's proceeding. However, you'll have an opportunity to present any relevant testimony and make any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose and procedure before we begin?
No, ma'am.
Okay, so we're going to go over the rights that you have for today's hearing. The first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you also have the right to cross-examine any adverse witnesses. Do you understand all these rights, and are you ready to go forward?
Yes, ma'am.
So we are now going to review the charges that the state or parole officer is bringing against you and the information underlying each charge. So for charge number 1, condition of absconder, the charging officer reported that on October 29th, 2024, you left Renaissance East, your only parole-approved residence, approximately 45 minutes after getting dropped off by the CTU van. You grabbed your property and ran out the front door of the halfway house. You have failed to make contact with the halfway house or your parole officer. Your whereabouts in the community are unknown at this time. On charge number 2, condition of travel, the charging officer reported that on 11/29/2024, you were apprehended in the state of Arizona by Phoenix Police and the Maricopa County Sheriff's Office. On 11/13/2024, you appeared in the Superior Court of Arizona, Maricopa County, and signed a waiver of extradition. You did not have permission to leave the state of Connecticut, and based on your actions, you're in violation of your release condition travel. The state has filed the following exhibits pre-marked for identification purposes as Exhibit A, the parole conditions, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the remand to actual custody order, Exhibit F, the halfway house agreement, Exhibit G, the Renaissance East absconder report, 10/29/2024, Exhibit H, the pictures of Thomas absconding from the halfway house on 10/29/2024, 5 photos, Exhibit I, the Central Avenue absconder incident report, 3/12/24, and Exhibit J, the signed waiver of extradition. In addition, the state has filed the following addendum to the parole violation report on November 18, 2024, and that's also admitted into evidence and reads as followed. In reference to the parole violation report submitted by Parole Officer Babbage regarding Thomas Timothy, number 4055566, the following applies. On November 12, 2024, the Board of Pardons and Paroles issued a warrant based on the report declaring Thomas an absconder from parole supervision. On November 12, 2024, the case was deferred to DOC Parole Fugitive Investigation Unit for investigations and apprehension. And on November 12, 2024, a lead packet was sent to the Phoenix, Arizona Police Department and the Maricopa County's Sheriff's Office requesting assistance with apprehending Thomas, who was at an urgent psychiatric center in Phoenix, Arizona. On November 12, 2024, Thomas was apprehended by the Phoenix, Arizona Police Department and is currently being held as a fugitive from justice at Maricopa County Jail, awaiting extradition to Connecticut. Please note this is Thomas's third time absconding from special parole supervision since he was discharged as special parole on 10/24/2023. Thomas was initially placed in the halfway house on 9/21/2023 and absconded on 10/27/2023. The BOPP approved a warrant for his re-imprisonment on 12/4/2023, and on 12/12/2024, Thomas was returned to custody. Thomas was re-released to special parole supervision on 3/12/2024, and a little over an hour later, he left the halfway house. The BOPP approved a warrant for his re-imprisonment on 4/15/2024. 4/23/24, Thomas was apprehended by NYPD. On 4/29/2024, he was extradited to Connecticut. For his current abscond, Thomas left the halfway house less than 45 minutes after placement on 10/29/2024, the day of his re-release to special parole supervision. On 11/12/2024, Thomas signed a waiver of extradition at the Superior Court of Arizona, Maricopa County on 11/27/2024. PO Carnagan, and Silva assumed custody of the absconder and extradited him back to Connecticut. The absconder was served his parole violation notice and parolee rights, while a remand to custody order was logged at HCC. Counsel, did you and your client receive the notice of parole violation, the parole violation reports, and all the other documents marked? Perfect. I did receive an exhibit from the defense. That's Exhibit 1, a list of parole accomplishments and plans, future plans for parole reinstatement. Is that correct, counsel?
Yes.
Do you need any more time to submit any additional evidence? No. So today we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges.
Yes, if I may just add regarding this, I did speak to my client, yes, on paper. This is a 45-minute in the community. My client lost his, not making an excuse for Mr. Thomas, but I just want to give you a little background as to what happened here. He lost his mother about 6 months ago. He just suffered from PTSD. When he left and went to Arizona, he did have a mental breakdown. He was not on medication at that time. He left here October 29th. I know the remand date on the paperwork shows 11/27, but it was actually November 12th. He went to the psychiatric unit in Arizona, and he's the one that called 911, knowing that he had left Connecticut. I know it says he was apprehended by the Arizona police, but my client did call 911. He was, and that's where they served the paperwork on him. So he was in Arizona from 11/12. He did voluntarily sign a waiver of extradition, but was not remanded back to Connecticut until November 27th. So the window seems longer, but he was in psychiatric unit on November 12th. Once again, I know this is bad. He was out for 45 minutes. I did speak to my client extensively via telephone. Since he's been in the facility, he is back on his medication. They have him being medication compliant. As I indicated, I on the travel, it appears like he ran into the Arizona in Arizona by the Phoenix police. That's not the way. It's not worded correctly, in my opinion, okay? My client indicated he did call 911. He was in the unit there. They came. He knew by calling 911, his name was going to come up because of the warrant out of Connecticut. He did sign the paperwork to be brought back to Connecticut. And he is, as indicated to me and to my social worker, he has taken his medication in the facility, and they have him on the medication that he's supposed to be on.
Thank you.
You ever worked for a guy?
So I am, just take a moment. So I'm going to make a finding. So I do find that you violated the condition of absconder based on the evidence presented in Exhibit A, B, and G. And I'm also going to find that you violated the condition of travel based on the state's exhibits A, B, and J. So that does conclude the fact-finding portion of the hearing. Before I make a recommendation, you will have an opportunity to speak to your background history, any pertinent information. So the purpose of this part of the hearing is to help me make a recommendation. So counsel, would you like to make a statement?
Yes, my client is 49 years old. He does not have any children. He was at the Connecticut Renaissance, as I indicated, the reason why he went to Arizona. He did work last as an electrician. He did begin studying computer science and strength conditioning at Keene College in New Hampshire. He did, once he was incarcerated and once he was released from that psychiatric unit, he does meet with a counselor at the health unit at McDougal. And he is taking his medication, is compliant, I believe he's taking his Zyprexa. So he's back on track where he's supposed to be. As I told Mr. Thomas, when I first picked up this file, on paper, does not look good. But I know it was a short period of time. He did not go out and commit any crimes. He did end up in Arizona. That's where his family is from. And they said he lost his mother. He went to the unit, psych unit, did call 911, knowing there was a warrant for him. And when they came over, immediately signed the papers. Hopefully, when he's reinstated, he'd like to be placed in that halfway house in Waterbury, preferably Renaissance East. Interested in studying computer science, and he needs to apply for mental health disability. That's been an ongoing issue for my client, and he's obviously amenable to any treatment recommendation. I know I think it was Babbage recommended something in the 9-month range. I understand, with times he keeps absconding, that it's going to be an issue for him. But I just wanted to put on a record and give you a little background as to what happened here with Mr. Thomas. Like I said, he didn't, take off within 45 minutes, go out and commit a new crime. He ended up in a psychiatric hospital, which I think is important to know. Mr. Thomas, anything you want to add that I left out regarding your treatment and now that you're back on track? Unfortunately, in the facility.
I just want to say my attorney's right. It did say in the report that I was apprehended. I actually turned myself in. I called 911 and told a fugitive from Connecticut and that I needed help. And that's when I was placed in a mental health unit. And then the police came. Then they took me into custody there. So I do recognize I need help. I need mental health treatment. I'm having severe mental health issues, and I just need help. I need help with my mental health, and I don't know. I'm sorry that I've scouted a couple different times. I feel like I'm on the right track. I'm on my medication now, and I appreciate the leniency. Thank you.
I do have a question. Does that mean that you were not compliant with your medication last time you were released?
No, I wasn't even taking my meds at the time.
He was not. I already put that on. Yeah, after speaking to him, like I said, I picked up this file and I see 45 minutes. It's a problem for me too.
Yeah.
And I go through my questioning. He was not on it. He went to Arizona, but then he realized that something was going to happen. That's why he checked himself and into the psychiatric hospital. But ever since he's been into the facility, we confirmed that through my social worker. He is medication compliant.
Okay.
And he realizes he's got mental health. He's got to stay on his medication.
Absolutely.
And it can't be on and off situation. Thank you.
Thank you.
Thank you.
So I have listened to the testimony and I did review all the evidence submitted, and I am going to recommend your parole be revoked and that you serve an approximate 10-month period of confinement. So that's with the re-parole date of September 27, 2025. In addition, I'm recommending the following conditions: no alcoholic beverage consumption, behavioral management program for anger management, a general no contact with JB, mental health evaluation, and halfway house placement in Waterbury. My recommendation is going to go to the board on February 6, 2025, and you'll receive a written decision following that date. At that hearing, the board can lessen my recommendation. They can let it stand, or they can impose a sanction longer than what I've recommended. If they do decide to impose a sanction longer than what I've recommended, a supplemental hearing will be held and will be notified, because you'll be present for it to answer their concerns and questions, okay?
Yeah, so what's the date of release? What's the date?
September 27th.
9/27.
And what, can I be credited for the 2 weeks that I was held in custody in Arizona? Does that count towards?
Well, no, that's my final decision. I'm doing 10 months from the date you were brought back to Connecticut, okay?
So it's the 22nd of September, you said?
9/27.
9/27. The board will make the final decision on February 6th, and you'll receive it in the mail, the written decision from them, okay?
Okay.
All right, good luck to you.
You're all set, Mr. Thomas.
All right, thank you.
Hyde.
Have a good day.
This concludes the final revocation for Timothy Thomas, inmate number 405566. Good morning. How are you?
Good. He's I'm giving him a call now. He should be ready, but I'll get him on his down here as soon as possible.
Perfect. Thank you.
Yep.
Yeah. Okay.
Good luck.
Thank you. Thank you.
Good morning, Mr. Ortiz. How are you?
I'm doing good. How about you?
Good. So we can't start until exactly 10:30, so we have about 4 minutes, okay? So just hang there. We'll get right to you soon, okay?
Okay.
All right, thanks.
You're welcome.
Good morning. I'm Parole Officer Trusello, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a revocation hearing concerning Jaciel Ortiz, inmate number 383441. Today is Monday, January 27, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
Jaciel Ortiz, 383441.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Attorney Sirica, can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Ortiz.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Ortiz, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, or not, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, sir. Dismiss.
Sir.
No, dismiss. Yes, sir. Oh, no.
He did say mishap. He did say mishap.
You can put your hand down, Mr. Ortiz.
Okay, sorry about
Thank
that.
you.
I'm nervous.
That's okay. Me too. I keep stuttering, so we're good. So, we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then I'm going to review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so we're going to go over the rights that you have for this hearing. The first is you have the right to be represented by an attorney and counsels here present for you. You have the right to receive the written notice of charges of violation. Did you receive that written notice?
He did.
Yes, miss.
Okay, so you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call any witnesses, and you have the right to examine any, cross-examine any adverse witnesses. Do you understand these rights, and are you ready to go forward?
Dismiss.
Okay. So we're now going to review the charges that the state, your parole officer, is bringing against you and the underlying information for each charge. So on charge number 1, condition of reporting, the charging officer reported that on 10/3/24 and 10/8/24, you failed to report in person to the New Haven Parole Office as instructed. You were aware of the dates and times but failed to report. On 7/13/24, you left your residence between the hours of 9 p.m. I'm sorry, I missed one. No, that was reporting. Okay, now we're on charge 2, GPS. So the underlying information is on 7/13/24. You left your residence between the hours of 9 p.m. and 6 a.m. You're in violation of your GPS agreement. On 9/19/24, 9/25/24, 10/1/24, and 10/5/24, you allowed your GPS unit to shut down due to failure of charging the unit. You again were in violation of your GPS agreement. On 10/3/24 and 10/4/24, you left your parole approved residence between the hours of 9 p.m. and 10 p.m. Again, you're in violation of your GPS agreement. On 10/8/24, you removed the GPS unit from your body without the consent from parole. As a result, you're in violation of your GPS agreement. Charge number 3, condition of program participation. On 9/5/24, you, upon discharge from the App Foundation, you were instructed to participate in individual outpatient treatment at the App Foundation clinic. You failed to attend and participate in your mandated substance abuse programs as instructed. On charge number 4, condition of obedience to law, on 10/11/24, you had police contact with the West Haven PD. You operated a motor vehicle in a reckless manner, causing parole and the West Haven Police Department to pursue you. As a result, you received the following new charges. 53A-167A, interfering with an officer resisting, 14-299, traffic control signals, 14-224B3, evading responsibility, injury, property damage, 14-36A, operate a motor vehicle without a license, 39A-371, failure to insure private motor vehicle, and 14-12A, failure to renew registration. You were scheduled to appear before the Milford GA22 court on 11/5/24. And charge number 5, condition of drugs, on 7/16/24 and 8/1/24, you rendered a urine sample for instant toxicology drug test. Both samples rendered positive for an illegal drug. You do not have medical authorization to possess, control, or use the substance/drug. The state has also filed the following exhibits that have been pre-marked for identification purposes. I have Exhibit A, the conditions of parole, Exhibit B, the remand to actual custody, Exhibit C, the parole violation notice / rights, Exhibit D, West Haven PD police report, Exhibit E, parole violation report, Exhibit F, misconduct, Exhibit G, the app transition plan, Exhibit H, the GPS agreement, Exhibit I, the GPS allied universal reports, Exhibit J, the judicial branch pending case detail, Exhibit K, the release of information, Exhibit L, the images of CT IDs for proposed sponsors, Exhibit M, the summons, Exhibit N, toxicology screening, biotech labs, Exhibit O, voluntary admission, and Exhibit P, text messages. In addition, the state has filed an addendum to the parole violation report on January 7th, 2025, and that's also admitted into evidence and reads as follows. On 10/11/24, Mr. Ortiz was arrested and charged with 53A-162, interfering with police officer, 14-299, disobeying a traffic signal, 14-224, evading responsibility, 14-36A, operating without a license, 14-12A, operating without proper registration, and 38A-371, operating without insurance. On 12/7, okay, we're good, doing good. 12/27/24, Mr. Ortiz appeared before the Milford Superior Court for the following charges on companion dockets: A22M MV24-0080877S and A22M-CR24-0126543S. Docket number A22M-MV24-0080877S were combined with docket number A22M-CR24-0126543S. Mr. Ortiz was sentenced and found guilty on the following three charges: 53A-162, interfering with police officers, 14-224, evading responsibility, and 38A-371, operating without insurance. He received 30 days jail with each charge to run concurrently. The remaining charges were marked nollie. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents?
Yes.
Great. I have received defense exhibits. I received a few. Let's grab it. All right, so I have Exhibit 1, a list of parole accomplishments and future plans for parole and statement. Exhibit 2, the certificate recognition for living in balanced Tier 2 drug and alcohol program. Exhibit 3, the offender accountability plan revision form. And Exhibit 4, the domestic violence program offender participation evaluation form. Is that accurate, counsel?
Yes.
Great. Do you need any more time to submit any additional evidence?
Yes.
Okay, so today we do not have any witnesses, so it is your time now to call any witnesses, present evidence, and to the charges.
Yes, if I may. Regarding charge number 1, Mr. Ortiz, do you recall parole officer indicated October 3rd, 2024 and October 8th of 2024? Why you didn't go in person to the New Haven parole office?
Because I got COVID.
Okay. You tested positive for COVID, and did you let your parole officer know?
Yeah, I sent a test with a paper for the paper they give me in the hospital, in jail hospital. And
Okay.
she said, okay, no problem. I send you the day you about to come see me back, and she never sent me. She never sent me the date.
Do you remember when the COVID was when you tested positive?
I think it's like the same day I sent the paper, like 2 days before that. The day she told me, oh, go. I sent the paper. I said, yo, I have COVID. I cannot go see you. And she said, no problem. I'm gonna reschedule you the day you can see me.
Under charge number 2 on the GPS, it looks like on July 13th of 2024 is approximately about an hour. Do you recall where you went for that hour?
I told her, she called me on Monday. She said, come see me in my office. And I told her, miss, I forgot, I had to go pick up my wife. Nobody, I got the car that time because I'm working in Tougher Tire. And I'm not supposed to go up that time, and I pick him up. I take only 20 minutes short. It's like 20, 25 minutes She see me wanna go all the way pick up her and come back to the house. I don't go nowhere. She got all those when I go to the hotel and come back. It's not like I go do something crazy or I go to the club or something like that. No, I go pick him up at the same time, like 12:20. When I come back, it's like 12:20. And she told me come to the office and she said, you know, I violated. And
So you picked up your wife was working at a hotel, correct?
in the hotel, yeah, she worked in the hotel right there and Hendon. And I told the location, everything. I told him, listen, I'm not lying to you. I pick him up. I'm not supposed to go nowhere that time because I know that's my mistake. But I got the car for that time, and that's why I pick him up. It's only like 20.
Hold on a second. Chaz, you told your parole officer where you went, and obviously it showed the time frame, and she was able to look at your GPS points there. So what you told her, she was able to verify, correct?
She verified right there, and she said, okay, she don't care because I'm not supposed to go nowhere.
Which is true. You didn't have a curfew, but the GPS points showed what you told her. She was able to verify with the GPS.
She verified. She verified, but she says she don't care. Like she because I'm making that's my fault. She said, okay.
And October 8th, where you removed the GPS, you knew on October 8th you were going back to jail already, correct?
She told me she about the home time off program. And I'm stressed because my mother, she live in Providence. I don't see my mother almost 7 years already. And they told me she got cancer. And I want to see her. I got almost 5 months with the bracelet. And I told them, listen, can you call my bracelet? And she don't want to call it. She don't want to take that out for me. And that time, I got a lot of stress. I started using drugs. And my mind is not 100%. And I called the bracelet. She called me the same day they called me. She said, Ortiz, I'm about to pick her in your house. I'm about to put you in timeout program. Because you called your bracelet, I'm about to put you in timeout program. 45-day timeout program. But that time, I scared. I see Matt police coming. And that's all I ran. I'm right there in the car, waiting for my sponsor to pick me up. And when I see all the police, I'm scared and I left. And that's how they pursue. But when they stop me, I don't put nobody in danger. I put my hands up and go to jail. It's not like I started to go crazy and I stop it. I say, you know what, let me stop it.
On charge number 3, I just want to clarify the program participation. You did, if I'm reading this correctly, you did successfully complete the APT Foundation. It was 30 days inpatient, correct?
Yeah, I did it 28 days in APT Foundation.
28 days, okay.
28 days. 28 days, APT Foundation. I graduated. They gave me certificate, everything. And she know because she had to give me the permission to get out from that program. She had to go and pick me up and say, Ortiz, you good.
All right, so the issue was with the follow-up part of it. Is that correct?
With the follow, I have to go. She want me to go voluntary 1 time a week. But I'm working at top retired. I'm working 8 in the morning to 5 o'clock at night. And the appointment's supposed to be in the morning at 11 o'clock. And my job, she don't want me to do it because I did already 30 days in the program. And she want me to do it and they don't want to wait for that. It's Ortiz. I cannot give it all days.
I just want to clarify this. This is on 9-5. The language here used upon discharge. It was a successful discharge, correct? 28 days you did. Okay.
28 days, yeah. I finished. Right. I finished the program.
Okay. I just wanted to give you a little background as to what happened here. So that's it for the first part of the hearing. That was charge number 5, that he self-admitted there's an issue with the substance abuse. And I'm going to talk about what he's done at the second part of the hearing since he's been there. Thank you.
Thank you. So I'm just going to take a moment. I'll let you know my findings.
Okay. And then when I did it.
Yeah, hold on. That's the second part. Hold on. You're jumping ahead. We're going to get to that. I promise you we're going to get to that.
Sorry about that. Sorry.
I do want to hear it, but I'm just going to announce my findings first, and then we'll move on to that, okay? So, charge number 1, I am going to find that you violated the condition of reporting based on the evidence in Exhibits A, E, and P. On charge number 2, I find that you violated the condition of GPS based on the evidence provided in Exhibits A, E, F, H, and I. And on charge number 3, I'm finding that you violated the condition of program participation based on the evidence provided in Exhibits A, E, and G. And on charge number 4, I found that you violated the condition of obedience to the law based on your conviction of interfering with an officer and evading responsibility and operating without insurance when you received a sentence of 30 days jail, with each charge to run concurrently. In addition, the following evidence supports the charge is A, D, E, J, and M. And lastly, on charge number 5, I found that you violated the condition of drugs based on the evidence provided in support of the charge, which is exhibits A, E, F, N, and O. So that does conclude the fact finding portion. This is, before I make my recommendation, you'll now have the opportunity to speak to your background history, any information that you feel is pertinent. So counsel, would you like to make a statement?
May I just make one comment? I know you made your findings. I just want to put on the record, in exhibit P, my client did send over a document, texted to the parole officer from Yale New Haven Hospital regarding the positive COVID test. It looks like it was sent at 5:11 p.m. And the response was, "Don't text me outside of business hours." That's Monday through Friday from 8 a.m. to 4 p.m. This one, so at exhibit P, yeah, it's like the 3rd page in. I just want, he did send it in. I'm not disputing your finding, but I just want to show you that my client did make an effort to send in the COVID test from Yale, and then that was the response to that. Okay, I'm not disputing your finding, but he did make an attempt, just so you know. He wasn't saying that just to say that. He did send it over to his parole officer, yeah. Okay?
Yep.
Thank you. Yeah, I just wanted, yeah.
All right, before you start, let me just write it down. You're nothing in. I wanted to review it. All right, counsel, would you like to make a
Yes,
statement?
on behalf of Mr. Ortiz, my client is 35 years old. He does have one 15-year-old son who lives in Florida. He did pay child support while he was out, and he does have contact with his son on a regular basis. Upon his previous release, he did have a sponsor. He also has indicated through that he did successfully complete, I want to make sure that's clear, the App Foundation. It was 28-day inpatient program. The issue was with the follow-up while he was working at Town Fair Tire. But like I said, I'm not questioning what the parole officer, it just says upon discharge. And I just want to make sure it's clear that he did successfully complete that 28-day inpatient program. Upon his previous release, he was in Project More in New Haven. And then looks like in 2023, also did some residential services at the Apt Foundation. He did also have some services at the Connections Halfway House. While in the program, he did have a case manager, Ms. Atkins. While he's been incarcerated in Robinson, he did obtain his certification. He enjoys culinary arts. Also previously started a barber program in New Haven. He has about 3 weeks left to finish that program. As he indicated through his testimony, his most recent job was employed full-time at Town Fair Tire in Orange. He'd been there on and off for the past 4 years. Also, while he was out, he worked full-time as a chef at a bakery in New Haven. He was there until he was remanded. As I indicated, a job at Town Fair Tire. As far as treatment, he did do an intake in Midwestern Council for Alcoholism, CCA, in New Haven. He was not recommended to engage in treatment services, but he did do the intake. He did start while he was out the domestic violence classes in New Haven. And since he's been remanded at this particular time, he's employed as a chairman as block. Just successfully complete the Tier 2 program on just recent January 9th of 2025. That was Exhibit 2. And he did successfully complete domestic violence. That's Exhibit 3 and 4. So he has been taking his time since he's been incarcerated seriously, he's been engaging in programs. I did indicate a sponsor, it's a family friend. It's Pepperlin. I provided you with the address and a phone number. He does want to get his barber license. He's indicated to us he's able to return to town for retire. He's been at that job 4 years on and off. They're also interested in applying at Chipotle Mexican Grill in Brantford, and he's amenable to any treatment recommendations. I said he did complete inpatient, but he needs to get going with the follow up on that. So, Ortiz, anything you want to add about your background of the treatment for when hopefully you're reinstated?
And they give me yesterday. I finished. They give me on Friday. I finished voices too.
Okay.
You know, pero I did the voices, but they give it to me late, and it's a Friday, and I finished, and they give me the certificate for tier 2 right here. I already got it, and the domestic class, the DV class I finished, the study session I finished too. I got all of them right here, and they give me certificate. You know, this time, you know, I know every time I fuck him on the street, but this time I know I got a problem and drugs, and I. I did it the best I can, you know, and I want to keep going doing good because all of the problem I have is drugs, and that's what I did. The voices, I did a tier 2, and now I go to NA meetings every Mondays, Wednesdays, and Friday. I go, and I want to, you know, but I'm here. For the time I'm here, the almost 4 months. I try to do the best so I can change my life because I don't change my life, nobody do it for me. And I want to, do the best. I want to get out of here and see my mother before she died, because they told her she don't got. I don't see from. I don't want to see it. I don't want to make a phone call and tell me my mother died. I want to see her, because it's bad, and I don't want to do that. I want to do the right thing. I want to do the right thing. That's why I don't want to.
All right, thank you.
Thank you, Mr. Ortiz. I'm just gonna take a moment and then I'll let you know my findings. My recommendation.
Thank you.
Okay, so I have listened to the testimony today. I've reviewed the evidence submitted, and based on all of that, I am going to recommend your parole be revoked and that you serve a 5-month period of confinement. That's with a re-parole date of March 11th, 2025. In addition to that recommendation, I'm going to recommend the following conditions. Behavioral management program for domestic violence, no contact with your victim AS, a general no contact with Liberty Bank at 171 Silas Dean Highway in Wethersfield, Connecticut, a general no contact with CC or CR, a mental health evaluation, and then I'm going to put the sponsor in. Mr. Ortiz, should I put in the halfway house placement for a backup plan, or is it?
Yeah, I gotta show the house already. I called the guys, everything already. He know the money. He got the money already to hold in the bed for me in New Haven. And the sponsor not going through. I want to recommend the sober house because I got the guy got the bed. He from New Haven. And
so you don't want to go to Miss Camper?
No, I want to go right there. I want to go there
first.
And they don't going through for my address. I want to go to sober house. It's better for me to.
So what you're telling me is you have no interest in the halfway house, correct?
No interest because halfway house is not good for me.
Okay.
Thank you.
So then, I have the sponsor. So my recommendation is going to the board on February 6th, 2025. You'll receive a written notice after that hearing date. At that hearing, the board can lessen my recommended sanction. They can let it stand, or they can impose a sanction longer than what I've recommended. If that does happen, you'll be notified because there will be a supplemental hearing that you'll be present for to address their concerns. Okay.
Thank you, Miss.
All right.
My day. What's my day?
Well, I'm recommending March 11th.
March 11th.
Yeah. Call our office. If you call our office on Friday, February 7th, just speak to one of my secretaries. I won't be here. Just ask if the board approved the recommendation. That way you'll know that you get
Thank
out
you.
March 11th. All right, good luck to
Thank
you.
you.
Good luck.
Thank
Keep
you.
doing
Thank you
good
for
things in
everything.
there. Keep going to those meetings, okay, Mr. Ortiz?
Thank you. Yeah,
All
thank
right,
you.
good luck.
Thank you.
Concludes the revocation hearing for Jocelyn Ortiz, inmate number 383441.
You guys all set? All set?
We're all set, thank you.
You're welcome. Have a good day.
Too. Okay, she comes up. I hope they answer.
Taylor. You can have a seat. Bring the vote here down here.
All right, thank you.
Good morning, Mr. Taylor. How are you?
On yourself?
Good. So we're going to get started. So I'm Parole Officer Tricello, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a revocation hearing concerning Douglas Taylor, inmate number 187390. Today is Monday, January 27th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Bridgeport Correctional Center. Can you please say your full name and DOC entry number for the record?
Douglas Taylor, 187390.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Taylor. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Taylor, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for the hearing today. First is I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then I'm going to review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So we're going to go over your rights for this hearing. So for your first rights, you have the right to be represented by an attorney at this hearing, and you have counsel here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state or parole officer is bringing against you and the information underlying each charge. So on charge number 1, condition of absconder, the charging officer reported that on 10/16/24, you left the Isaiah halfway house without authorization. You have no further contact with Isaiah's staff or this officer. You left your only parole-approved address without program completion or permission and became unaccountable in the community. Subsequently, your whereabouts in the community were unknown. And on charge number 2, condition of halfway house placement, the charging officer reported that on 10/16/24, you left your only special parole approved residence, the Isaiah halfway house, without authorization and didn't return. You failed to contact your parole officer or halfway house staff, and you failed to return to the program. Your whereabouts are unknown at this time. Also, your actions violated your signed halfway house agreement, specifically the clause which reads, I will not leave the physical confinements of the halfway house unless authorized by program staff or parole. I will only go to the locations indicated on the approved community pass unless changes have been authorized by staff. The state has also filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the signed PCS conditions, Exhibit F, the signed halfway house agreement, Exhibit G, the Isaiah halfway house incident report. In addition, the state has filed an addendum to the parole violation report, and they submitted it on November 21st, 2024. That is also admitted into evidence, and it reads as follows. In reference to the parole violation report submitted by Parole Officer Elger regarding Taylor Douglas number 187390, the following applies. On November 15, 2024, the Board of Pardons and Paroles issued a warrant based on the report declaring Taylor an absconder from parole supervision. On November 18, 2024, the case was deferred to DOC Parole Fugitive Investigations Unit for investigation and apprehension. On November 21st, 2024, Taylor was apprehended in the Bridgeport Park by this FIU Officer Silva, along with Bridgeport District Office officers. Taylor was admitted to Bridgeport Correctional Center, where a remand actual custody order was lodged without incident. Taylor was served his notice of parole violation as well as his notice of parolee rights on the same day. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the documents that have been identified?
Yes.
Great. In addition, I have received an exhibit from the defense, which is Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Is that accurate, counsel?
Yes.
Do you need any additional time to submit other evidence?
No, thank you.
So today we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges.
Yes, as to the charges, I just have some general comments. From speaking with my client and understanding his perspective on what happened, it is, I believe, an unfortunate situation. My client had been doing well in the community for several months, but unfortunately was having some difficulties while in the halfway house. He reports that while he was there, many of his personal items, including money, credit cards, things of that nature, were going missing left and right. And when he did address this with staff, he unfortunately was not given assistance to prevent this from happening again. So he, I believe, felt as though himself and his personal items were not safe in that environment. So those are my comments as to the charges. At the appropriate time, I would like to remark on his background and future plans.
Okay, thank you. I'm just going to take a moment. I'll let you know my findings. So on charge number 1, Mr. Taylor, I am going to find you violated the condition of absconder based on the evidence that has been provided in exhibits B and E. And on charge number 2, I'm also going to find that you violated the condition of halfway house placement based on the evidence provided in exhibits B, E, F, and G. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you and your counsel have the opportunity to speak to your background, history, and make any relevant comments. Counsel, would you like to make a statement?
Sure, thank you. My client, Mr. Taylor, is 49 years old, born and raised in the Bridgeport, Connecticut area. His primary support in the community is his wife, Ms. Taylor, who he has been together with for 24 years. He has one child who's 19 years old, and then he also assisted Ms. Taylor in raising her children as well. Most recently, while on special parole beginning in March 2022, Mr. Taylor was placed at Isaiah Halfway House in Bridgeport. Previously, he utilized Renaissance Maple Street Halfway House from March 2021 until June 2021. He does have a high school diploma, GED, that he received in the 90s. In 2013, he graduated and obtained a culinary degree while at the Radagowski Correctional Facility. That was an 18-month program that he completed. While at the Maple Street Halfway House, he was working at American Fabrication, making furniture, and then he was also part-time at Hartley and Parker in Stamford, was there for about 2 months, and then he was at the furniture making business for about 1 year until he got laid off. From May until June 2021, he was doing men's cognitive behavioral therapy at Connecticut Renaissance in Bridgeport. He also reports that he was working with J Brothers program and did complete that, and was also working with New Visions Ministries in Bridgeport. Specifically, there was someone there named Elder Mack who he was working with and got his Ocean 10 while he was there as well to further his education. He has custody insurance. He does have some medical issues, including diabetes, asthma, high blood pressure. Since he's been at Osborn, he's been on the list for employment. Upon reinstatement, he would love to be sponsored by his wife. If possible, I did speak with her, Ms. Lashika Taylor. In the alternative, he's open to a halfway house in the Bridgeport community due to the proximity of his support network and his employment opportunities there. He's interested in going back to school, perhaps a trade school to help further his career. He's open to all sort of employment opportunities. He's eager to get home and care for his wife. She does need to get hip surgery. He's her primary help in the community, so he's really wanting to get back to help her. He also feels that he could benefit from some ongoing psychotherapy, perhaps CBT. So he's looking to get into some sort of treatment for that when he gets out. And then he's also looking forward to getting back with his medical providers and getting back on the right regimen of medications. He's been incarcerated for a little over 2 months. I would ask that he be given the soonest possible re-parole date. His special parole ends, I believe, in 2026. And so I know that he really wants the support of parole so he can get reinstated, get back on his feet, get a job, get to treatment with their support. So I know he is hoping to get out as soon as possible. I also can note from speaking with his wife, I do believe that she will be a very positive support for him. I think that he had done a lot of good things while in the community before to try and get himself back on his feet. So I would just ask for the soonest date so he can get back out. Thank you.
Thank you. What do you have his wife's?
Her name is Sirica Taylor. I should have a phone number for her.
No address.
Do you have the address for your wife's home?
Yes. It's in 141, it's Ansonia.
I need the full address so I can put it in the system.
149 Howard Avenue, Ansonia, Connecticut.
Thank you.
And that is your first choice?
Yes.
The sponsor? Okay. All right. And then I'll grab the phone number.
Yes, I should have that somewhere in here. If I don't have it down here, I have it upstairs.
All right. Just give me a minute and I'll let you know my recommendation. So I have listened to the testimony today. I've reviewed all the evidence submitted. And based on that, I am going to recommend your parole be revoked, Mr. Taylor. I'm going to recommend a 7-month period of confinement, which is a re-parole date of, just confirm, December, January, February, March, April, May, June 21st, 2025. In addition to that date and recommendation, I'm going to recommend the following conditions: no contact with the victim TS and LT without your parole officer's permission, and a mental health evaluation. And we're going with sponsors, so I will not do the halfway house.
Is the if I may just inquire, the LT, is that I know you can't say the full name on the record. I just want to make sure that's not his wife.
Oh, it is.
They still have that on there. I would just I understand that you're stating your findings. I would just argue, I believe that she was on there from an incident that happened years and years ago, where I don't believe there were any charges that stuck. I think that they may have been involved in alleged domestic incident. However, I think all charges related to that were nollied. So I don't think there, and I can confirm as well that there's no active protective orders or anything like that.
Okay, so I do have to keep that on. What I'll do is I'll still put her in as a proposed sponsor. It's up to Parole and Community Services, so I'm where they want to place you. But then I am going to just recommend the halfway house as well.
Okay.
Because it is up to them. I can't make the decision. But yes, that is it. So I'm going to keep that on for now, just because it's there. The board can do what they need to do. Also, so yeah, so my recommendation is going to go to the board on February 6th, 2025, and you'll receive written notice about the decision shortly after that date. At that hearing, the board can lessen my recommended sanction. They can let it stand, or they can impose a sanction longer than what I've recommended. If they do choose to go with a sanction longer than what I've recommended, a supplemental hearing will be held and you'll be notified, because you'll be present for that hearing to address their issues, concerns, any questions they have for you, okay? So that is all for today. Mr. Taylor, do you have any questions?
No.
So this does conclude the final revocation for Mr. Douglas Taylor, inmate number 187390. You are all set, Mr. Taylor.
Thank you. And sir, if you want to call my office on the 6th, we can let you know what the board decided, okay?
All right,
Thank you. If you have any questions as well, feel free to call.
all right.
Uh-oh, I can't see it yet. Hi, good morning.
Good morning. If we can start with Mr. Brayman, that'd be great.
Freeman, okay, they're not here yet. I just wanted to ask you, I was just about to email you and let you know about Lazada. He's in the flu dorm. Is it something that can be rescheduled or does he need to be here? If so, we can have him last when everyone's out.
I mean,
I don't want to reschedule it.
Yeah, no, he can come.
He can come down?
last. Yeah, that'd be
Okay, I'll
great.
do him last for you. And I'm just
Okay.
waiting for the other guys to get escorted down.
Okay, perfect. Thank you.
You're welcome. Thank you. I'll put you on mute for now.
Okay, thanks.
Thank you.
Right here?
Yep, you can have a seat.
Hi, Mr. Brayman.
Yes, ma'am. How you doing?
Great. I'm Officer Trisella. We can't start for 3 minutes. Unfortunately, we have to wait till exactly 11:30. Okay, so we'll be right
Okay.
with you. All right.
Yeah.
Hey, good morning. I'm Parole Officer Trisella. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Clay Brayman, inmate number 419670. Today is Monday, January 27, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, it's Clay Michael Brayman. My inmate number is 419670.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Clay Brayman. Good morning.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not that allegation is true. Excuse me. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Brayman, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're gonna go over the procedure for your hearing now. The first is I'm gonna read you your rights, then we're gonna review the parole violation charges that the state, your parole officer is bringing against you, and then gonna review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings, however, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings, and if I find that you have violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over the rights you have for this hearing, and the first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes, ma'am, I understand.
Perfect. So we are now going to review the charges that the state your parole officer is bringing against you and the underlying information for each charge. So on charge number 1, condition of absconder, the charging officer reported that on 1/6/21 you left Fellowship House, your only parole approved residence, without permission or program completion. Your whereabouts in the community are unknown, and you have failed to make contact with halfway house staff or your parole officer. And on charge number 2, condition of travel, the charging officer reported that on 11/7/2024 you appeared in the Fulton County, Kentucky District Court and signed a waiver of extradition. You're being held as a fugitive from justice after being apprehended by Hickman County Police. You did not have permission to leave the state of Connecticut, and based on your actions, you are in violation of your release condition travel. And on charge number 3, condition of halfway house placement, the charging officer reported that on January 6, 2021, you left Fellowship House, your only parole approved residence, without permission or program completion. Your whereabouts in the community are unknown, and you have failed to make contact with halfway house staff or your parole officer. The state has filed the following exhibits that have been marked for identification purposes. They are marked as Exhibit A, parole conditions, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the remand to actual custody order, Exhibit E, the halfway house agreement, Exhibit F, the Fellowship House absconder incident report, Exhibit G, the text conversation between Bremen and P.O. Babbage, 13 pages. Exhibit H, the signed waiver of extradition. And they have also submitted a Fellowship House consent and acceptance that I'm identifying as Exhibit I. In addition, the state filed an addendum to the parole violation report on November 1st, 2024 that is also admitted into evidence and reads as follows. In reference to the parole violation report submitted by P.O. Babbage regarding Bremen Clay number 419670, the following applies. On February 11, 2021, the Board of Parole issued a warrant based on the report declaring the offender an absconder from parole supervision. On February 17, 2021, the case was transferred to the parole officer and suite for investigations. On 10/22/2024, a lead package was sent to Hickman, Kentucky PD, where Mr. Bremen was located and taken into custody. A copy of the warrant and the remand was supplied to both Hickman Police Department and the Fulton County Detention Center, where Mr. Bremen is currently being held. On November 7, 2024, Bremen signed a waiver of extradition at the Fulton County District Court. Bremen was extradited back to Connecticut on December 20th, 2024, and Bremen was returned to Hartford Correctional Center, where remand to custody was lodged as approved by P.S. Waldron. On the same day of December 20th, 2024, Bremen signed the notice of violation and parole rights and was provided with copies. So did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
We received everything except for that Exhibit I, the Fellowship House consent and acceptance.
I think it was part of the Fellowship absconder report. I separated into two just because of the consent.
So that would be Exhibit F.
It looks like, or maybe here up.
Let's see.
Maybe I assume
the halfway house agreement.
Yeah.
Let's see. Okay, yeah, I see the second. Thank you so much.
No problem.
Yes, we've received everything.
Okay, great. Okay, so I also did receive an exhibit from the defense, and that's Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate, counsel?
Yes, thank you.
Do you need any time to provide additional evidence?
No, we don't, thank you.
Okay, so at this time, we do not have any witnesses, so it is the defense's opportunity to call in witnesses, present evidence, and speak to the charges and the evidence submitted.
Yeah, thank you. So I just have some global comments about the different charges. So my client was cooperative with extradition back to Connecticut to handle this parole violation. He's been in the community since December 2020, has picked up any cases during that approximately 4-year period. He also reports that he's been sober for the duration of that time and is finally getting his life together. He's built a support system, has been working, got, I believe, a long-term partner, and has a very supportive network now. I mean, we both know that people, places, and things are typically the biggest triggers to relapse, which Mr. Bremen has struggled with in the past. But I think it's worth noting that he has remained clean and crime-free in the community for a substantial period of time. And I think that is due in large part to the support system he's built for himself. And then at the appropriate time, I would just like to make comments about his background and future. Thank you.
Thank you. So I'm just gonna take a moment, I'll let you know my findings. So for charge number 1, condition of absconder, I do find that you violated that condition based on the evidence provided in Exhibit A, B, and F. For charge number 2, condition of travel, I also find you violated that condition based on support of the evidence that supports the charge, which is Exhibit A, B, and H. And on charge number 3, I found that you violated the condition of halfway house placement based on the evidence provided in State's Exhibits B, F, and I. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to Mr. Bremen's background, history, violation, anything that's pertinent for the case. So counsel, would you like to make a statement?
Yes, thank you. Mr. Bremen's 30 years old, born in Westerly, Rhode Island, raised in Pawcatuck, Connecticut. He has a strong support system, which consists of his 2 grandmothers and a grandfather who all live in New York, his significant other, Miss Stewart, and her father, who both live in Kentucky. He also has 3 children, ages 10, 8, and 3, who reside in Tennessee. They were the driving force that made him move after ending the relationship with his child's mother. He did relocate to Kentucky so that he could still be close to his children. Most recently, upon release to discretionary parole, after he successfully completed the timeout program in December 2020, he was placed at Fellowship Halfway House in Groton. He graduated from Stonington High School in Kentucky. He reports that he was landscaping full-time with a friend for about the past 3 years. Beginning in December 2020, while at Fellowship House, he was doing medication-assisted treatment, methadone, and was doing individual therapy as well at Root Center in New London. In Kentucky, my client reports that he was helping neighbors with yard work when they were in need. He was doing medication-assisted treatment in the form of methadone and will begin participating in weekly methadone groups while incarcerated. During all incarcerations that Mr. Bremen has had, he's never once had a disciplinary report. So I would argue that he is a really model inmate in that regard. Upon reinstatement of special parole, he's open to being placed in a halfway house, either in Hartford, New London, or Waterbury. He would like to return to the life he created in Kentucky eventually, and would like to be sponsored by his partner's father, Mr. Stewart, in Hickman, Kentucky. He also wants to further his education. He's open to enrolling in tractor training school to get his CDLB. He also is open to any sort of job opportunities and all treatment recommendations, and also wants to keep doing the methadone program and participate in individual therapy. His EOS date per the DOC is later this year in June. I'm just asking that he be released prior to that date so that he can establish some services in the community with parole's assistance. This is in a situation where there's new criminal charges, and I think he was doing very good while he was out. So I would just argue that he should be given an opportunity to establish services with the help of parole. Thank you.
I do have a question. Did you mention that he was participating in the MAT program in Kentucky as well?
Were you doing, I'm not sure if he was doing it while in Kentucky. Were you doing medication interest?
I wasn't able to because the closest clinic they had was about 3 hours away, and I wouldn't be able to, commute every day for 3 hours back and forth because of job and whatnot. So.
Okay.
Yeah.
So you were just clean on your own out there? No programs or anything? Were you participating in anything?
Yes, ma'am.
Thank you. Just give me a moment. I'll let you know my recommendation. So I have listened to the testimony today. I've also reviewed all the evidence provided. Based on that, I am going to recommend that your parole be revoked and that you serve an approximate 6-month and 8-day period of confinement as a sanction, which is a no new re-parole date, as your current end of sentence is June 28th, 2025. In the event that the board decides to lessen my recommendation, I will recommend the following conditions. No contact with your co-defendant, Donald Jarris. No contact with the victims, AW, CH, LK, and JS. A general no contact with CB, a mental health evaluation, and a halfway house placement in Hartford. So that is my recommendation. It's going to be forwarded to the board on February 6th. And you will receive a written decision shortly after that date. At that hearing, the board can only lessen my recommendation or they can let it stand. So you'll be just notified of their decision after that day, what they chose to do, okay? Do you have any questions right now, Mr. Brayman?
No, ma'am.
If you have any questions, feel free to call my office and I can discuss whatever you need with you, okay?
All right.
This does conclude the final revocation for Clay Brayman, inmate number 419670. All right, you're all set, Mr. Brayman.
Good luck,
All right,
good
thank
luck.
Okay. Hi. Are you
How you
Mr.
doing?
Holman?
Yes, I am.
Mr. Holman, it's always a pleasure to see you. How are you doing?
I'm doing okay. Just hanging in there. Yourself?
This is Mr. Holman.
Okay.
Yeah, he's not represented at this time. Thank you. So Mr. Holman, I am Officer Trusello. I'm the hearing examiner at the Board of Pardons and Paroles. And this is your preliminary hearing. No attorney, no appeal. Okay. So this is your preliminary hearing and it's concerning Jonathan Holman, I mean, number 367233. Today is Monday, January 27, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, Jonathan Holman, 367233.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. So Mr. Holman, I just want to talk to you quickly. I know you did request an attorney. Is that correct?
Yes, I have an attorney for this case, but I don't know if my attorney can be for this hearing.
A private attorney, correct?
Yes.
So they can be. They just have to file an appearance with us. Have you talked to them at all?
It's all new, so it's like I didn't even know this was gonna happen today. And I don't know if he know either. So
okay. Would you like me to continue the case for you to speak with him and have him represent you here, or what is your plan?
Yes.
Or would you like to move forward without representation?
Can he be here today, or we'll have to start a new hearing?
You said, can he be here today?
Yeah, or we'll have to start a new hearing.
I'd have to continue you to a later date. Ideally, I can put you on my next hearing, but that's next Tuesday, and sometimes that's not enough time. I don't know who he is, what his schedule is, so it might be best, like, if we do that, we could continue it one more time again if we need to, if you would like him here. It's completely your right. So those are two options today. We can continue the case so you can speak with him. He has to file an appearance with our office, so tell him to get in contact with us, or we can move forward today without counsel present to represent you.
I think I can move forward.
You're gonna move forward? Okay.
I think I'll move forward.
So there's gonna come a few times, I'll ask you maybe once or twice more before you can stop this to get representation, okay? Because once findings are announced, any of that, it's done for today, okay? But as long as you're sure, we can keep moving forward right now. Is that still okay?
Yes, I'm sure.
Okay, Mr. Holman. So I'm going to go over the purpose of today's hearing. It is a preliminary hearing and it has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Holman, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
So we're going to go over your procedure for today's hearing. So first I am going to read you all of your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'm then going to review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, yes, I do have a question. Okay, I have a co-defendant for this case.
Mr. Holman, but I also want you to be aware you're pending charges. I do not want you to incriminate yourself because anything you say today can be used against you in any courthouse across the state, okay? So just be mindful of what you want to say and what's needed to be said, okay?
Okay.
Do you still want to ask your question?
Yes, please. I just want. I think it's detrimental to the hearing.
Okay.
As far as my co-defendant, he cleared my name with my parole officer, which was kind of a little too late because I already was violated. But now I have him sworn to my lawyer to write a statement on himself to clear my name.
Okay, so that's still pending though, correct?
Yes.
Okay.
Because he was supposed to do it today. I'm not sure if he did it already.
Okay.
So my lawyer can have it notarized and hand it to you guys and the prosecutor.
Okay. So yeah, so that, I mean, that can be submitted to us whenever needed. At this point, we are just here to see if more likely than not something happens. So that's what probable cause is, as I'm going to review the charges, the evidence submitted. I'm going to make the finding as to yes or no and tell you what happens. Because the outcome of this could be that you'll be released, or it could be staying in jail pending your revocation. There's a lot of options to this. So I'm going to go over this one more time with you. You do have the right to be represented by an attorney at this hearing. You may hire your own attorney. It sounds like you have one. And it is your right to have them here. Are you looking to have them represent you for this preliminary hearing?
I don't feel like I need him.
You do not feel like you need them? Sorry, I couldn't hear you. You do not feel like you need them?
Yeah, I don't feel like I need him here.
Okay, that's okay. I just want to make sure. And again, I'm just going to be annoying with it. You have the right to remain silent. You're pending charges, so just be mindful, okay?
Okay.
So just to confirm, for the third time, I'll do it 3 more times. You are okay to move forward.
I appreciate it.
You're okay to move forward right now without your legal representation?
Yes, I am.
Okay, all right. So then you also have the right to receive written notice of the charges of your violation. Did you receive that written notice?
Yes, today I did, actually.
Okay, were you able to review it?
Yes.
Okay. You also have the right to review the evidence against you. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine any witnesses. Do you understand all of these rights, and are you ready to move forward?
Yes.
Okay, so I'm going to review the charges that the state, your parole officer is bringing against you and the underlying information for each charge. So it is just the one charge, and it's for charge number 1, condition of obedience to the law. The charging officer reported that on January 9th, 2025, you were served an outstanding arrest warrant by Shelton Police. According to the arrest warrant issued by the court honor about 10/2/2024, you were charged with larceny 2nd degree and conspiracy to commit larceny in the 2nd degree. Charges stem from you possessing and attempting to cash stolen lottery tickets. On January 10th, 2025, you were arraigned in Derby Superior Court and with a return to court on February 20th, 2025. Just so you know, in regards to this charge, a judge of the Superior Court of the state of Connecticut has already determined that there's probable cause to believe that you committed the act of larceny 2nd and conspiracy to commit larceny. Sorry, it's conspiracy to commit larceny 2nd. So I cannot revisit that. And the finding and charge will not be considered. So because the court has already determined probable cause, there's nothing I can decide whether or not it did happen or not happen because there's an assigned arrest warrant, okay? So I just want to make you aware of that. So we really don't have to take much testimony at this time, but I do want you to know about the exhibits that have been filed. So the state filed Exhibit A, the notice of parole violation, Exhibit B, the parole violation report, Exhibit C, the remand to custody, Exhibit D, the parole conditions, Exhibit E, the arrest warrant application by Shelton Police, and Exhibit F, the judicial branch pending case details. So one more time, you did receive that, you said, and you've been able to look over everything?
Yes.
I have not received any evidence from you. We don't have witnesses. So at this time, it would be your opportunity to respond to the parole violation charges against you. However, remember that you do have the right to remain silent if you choose to do so. I have noted what you said about your co-defendant working on stuff. So I will just make note of that at this point, that there's stuff going on in your court proceedings. So are there any additional comments that you would like to make at this time regarding the charge? Do you have the right to remain silent?
No.
Okay. As stated before, I am making the finding of probable cause on charge number 1, condition of obedience to the law based on the signed warrant from the Superior Court judge. In addition, the state has filed exhibits that support the charge, which is Exhibit B, D, E, and F. And due to that, I do find that the act is serious enough to warrant a revocation, and I've determined that you should remain detained while you wait your revocation hearing. So the records department and your parole officer will be informed. Your revocation hearing will be scheduled upon the disposition of that criminal case, okay?
Okay.
So once that's settled, whatever happens in court, your parole officer will contact us, let us know the outcome of it, and then we'll bring you back in for a revocation, all right?
Okay.
All right, do you have any questions for me right now, Mr. Holman?
No.
All right, good luck, Mr. Holman. I wish you the best and hope it all works out, okay?
Okay, thank you.
Thank you. This does conclude the preliminary hearing for Jonathan Holman, ME number 367233.
Yeah.
Okay, come on, Mark.
I just had a full conversation with you muted. I'm so sorry. Good morning, Mr. Gardner. How are you?
Good morning. I'm good.
Good morning.
How are you?
Good. I'm good. I'm gonna go grab your attorney and I have to call your officer to get him on the line and then we'll start, okay?
Yes, ma'am.
Okay, great. Thank you. Yeah. Hello, Sir Davis, are you with us? Officer Davis, are you there?
Yes, I am.
Okay, great. All right, so we are going to start. So I am Parole Officer Trissello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing. I hear noise, but it's him. This is a preliminary hearing concerning Mark Gardner, inmate number 374513. Today is Tuesday, it's Monday, January 27th, 2025. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Mr. Gardner, can you please state your full name and DOC inmate number for the record?
Yes, it's Mark Gardner, 374513.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti and Parole Officer Davis. Attorney Famiglietti, can you please identify yourself for the record?
Sure. Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, everyone.
Officer Davis, can you please identify yourself for the record?
Good morning, Parole Officer Patrick Davis. I work out of the Hartford District Office.
Thank you. This is a preliminary hearing and it has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe that you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Gardner and Officer Davis, please raise your right hands. Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
I do.
Thank you. So we're going to go over the procedure for the hearing. First is I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Me? No. No question, no.
Okay, so we're going to go over the rights you have for this hearing. And the first is you have the right to be represented by an attorney, and counsel's here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
That's this document.
Yeah, I believe so.
Yes, I did. Yeah, right. And you were able to review it?
Yeah, pretty much.
Okay. Great. So you also have the right to review the evidence that has been submitted against you for this hearing. You have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am. I'm ready to go forward.
Great. So we are now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. Officer Davis, can you please read the charges and the underlying information?
Yes, I will. Number one, release direction, charge number one, GPS. On 6/7/24, you were placed on GPS at initial intake due to previous noncompliance in the community. At this time, you were instructed on and agreed to properly charging your GPS unit for 2 hours daily. On the following dates, you failed to properly charge your GPS unit as instructed, resulting in your GPS unit shutting down. On 6/10/24, you allowed your GPS unit to shut down from 7:16 until 7:24 p.m., resulting in 8 minutes of your whereabouts in the community being unknown to this parole officer. On 6/14/24, you allowed your GPS unit to shut down from 3:54 p.m. until the next day, 6/15/24 at 1:45 p.m., resulting in 21 hours and 51 minutes of your whereabouts in the community being unknown to this parole officer. On 6/24/24, you allowed your GPS unit to shut down from 10:38 p.m. until the next day, 6/25/24 at 12:10 a.m., resulting in a 1 hour and 32 minutes of your whereabouts in the community being unknown to this parole officer. On 6/26/24, you allowed your GPS unit to shut down from 11:35 a.m. until 3:40 p.m., resulting in 4 hours and 35 minutes of your whereabouts in the community being unknown to this parole officer. On 7/5/24, you allowed your GPS unit to shut down from 6:53 p.m. until 9:19 p.m., resulting in 2 hours and 26 minutes of your whereabouts in the community being unknown to this parole officer. On 7/7/24, you allowed your GPS unit to shut down from 5:50 p.m. until 6:42 p.m., resulting in 52 minutes of your whereabouts in the community being unknown to this parole officer. On 7/16/24, you allowed your GPS unit to shut down from 6:13 p.m. until 9:55 p.m., resulting in 3 hours and 42 minutes of your whereabouts in the community being unknown to this parole officer. On 7/19/24, you allowed your GPS unit to shut down from 10:07 a.m. until 6:23 p.m., resulting in 8 hours and 37 minutes of your whereabouts in the community being unknown to this parole officer. On 7/20/24, you allowed your GPS unit to shut down from 8:32 a.m. until 8:54 a.m. and from 11:17 p.m. until the next day, 7/21/24 at 1:14 a.m., resulting in 2 hours and 23 minutes of your whereabouts in the community being unknown to this parole officer. On 8/4/24, you allowed your GPS unit to shut down from 11:35 a.m. until 12:31 p.m., resulting in 56 minutes of your whereabouts in the community being unknown to this parole officer. On 10/3/24, you allowed your GPS unit to shut down from 4:14 a.m. until 9:45 p.m., resulting in 17 hours and 31 minutes of your whereabouts in the community being unknown to this parole officer. On 10/19/24, you allowed your GPS unit to shut down from 6:40 a.m. until 6:47 a.m. and from 9:30 p.m. until 9:49 p.m., resulting in 26 minutes of your whereabouts in the community being unknown to this parole officer. On 10/23/24, you allowed your GPS unit to shut down from 1:40 p.m. until 5:36 p.m., resulting in 3 hours and 56 minutes of your whereabouts in the community being unknown to this parole officer. On 12/10/24, you allowed your GPS unit to shut down from 10:42 p.m. until 10:47 p.m., resulting in 5 minutes of your whereabouts in the community being unknown to this parole officer. On 12/17/24, you allowed your GPS unit to shut down from 1:37 a.m. until 8:33 a.m., resulting in 6 hours and 56 minutes of your whereabouts in the community being unknown to this parole officer. This resulted in approximately 94 hours of accountability in the community with location unknown to this PO. On all occasions above, your whereabouts in the community were unknown to this PO, which is a violation of your signed GPS agreement. Number 2, obey all laws. Charge number 2, obedience to the law. On 12/21/24 at approximately 6 p.m., you were arrested by the City of Groton Police Department. On the above date and time, you were seen exiting the parking lot of the Roadway Inn and traveling well above the posted speed limit of 25 miles per hour. The Roadway Inn is an area well known to law enforcement for narcotics trafficking and prostitution. At this time, a traffic stop was conducted. Before the arresting officer exited his cruiser, all 3 occupants in the vehicle, to include yourself, got out of the vehicle and began to walk away. You stated to the arresting officer that since you were already out of the vehicle, the officer was unable to pull you over. You were instructed to get back into the vehicle, but you refused to listen to verbal instructions and commands. During the stop, you continued to yell to responding officers, "You aren't searching my car." Your non-compliance with officers continued throughout the entire stop. Due to your behavior, you were subsequently arrested and charged with 14-215, illegal operation of a motor vehicle under suspension, 14-12A, failure to renew registration, 53A-167A, interfere with officer and resisting, and 12-218A, traveling unreasonably fast. Ultimately, you were issued a misdemeanor summons, MB 823605, with a court date of 1/3/25 at GA10. You were released on a promise to appear. Charge number 3, notification of arrest. On 12/21/24 at approximately 7 p.m., you reached out to this officer that you had police contact. You failed to mention that you actually got arrested and pulled over by Groton Police Department. This PO also gave you an opportunity to tell the truth during a reporting session, and you also failed to do so. This PO had to reach out to the Groton Police Department to get the details of what actually transpired. This is a violation of your signed parole agreement. Number 2, obey all laws. I will notify my parole officer within 48 hours of my arrest for any offense. Would you like me to read the exhibits?
No, because I actually re-identified some of them, so I'll do it. Thank you.
Yep, you're welcome.
So the state did file the following exhibits. I have remarked them for identification purposes. But Exhibit A, the remand to actual custody order. Exhibit B, the statement of understanding the agreement conditions of parole. Exhibit C, the signed GPS agreement form. Exhibit D, the parole violation notice. Exhibit E, the parole violation report. Exhibit F, the police report, misdemeanor summons and complaint. Exhibit G, the offender misconduct. Exhibit H, the decision information summary. And Exhibit I, the Allied Universal reports. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, ma'am.
Okay. So I have not received any exhibits from the defense. Is that accurate?
That's accurate.
Any time to submit any evidence?
No, we do not.
Okay, so then we do not have any witnesses today. So at this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegation. So Officer Davis, would you like to make a statement regarding the charges?
No, just that the, all the GPS violations speak for themselves. I included them as the evidence, and on 12/21/24, the offender or the subject did get arrested, and the police report's in there as well. Thank you.
Thank you. All right, and counsel, it is now your opportunity to speak to the charges. Would you like to make a statement?
Oh, yes, briefly, just as a probable cause. I've got no comment as to charges 1 or 2. Clearly, my client did reach out and notified the parole officer of this incident. He did notify him that he didn't have contact, and I would argue that that is sufficient. He may not have even known he was quote unquote arrested. When you get arrested, most people think you get arrested, you're taken into custody and you're brought to the police department. He's nodding in the affirmative. That is the standard commonplace understanding of what an arrest is. If you look up the Black Law Dictionary, it's basically a removal of your liberty is an arrest. That was not done. And this is not a case where he didn't inform his PO at all. At 7 p.m. that evening, which was not long after the incident, he did notify his parole officer of the police contact. That's the reason why the parole officer was able to go and check with the police department. So I don't believe there's probable cause for charge 3. As to the seriousness of the allegations, he was given a promise to appear for this misdemeanor summons. Telling the police when they ask you, can we search your car? No, you cannot search my car, is exercising your constitutional right. It is not resisting arrest. So I don't believe that resisting arrest charge is serious, and I certainly don't think the elements are going to be made in court. It's essentially a misdemeanor summons for a motor vehicle incident. And then it appears as though for a long period of time, almost the whole time before his arrest, or his remand, the whole time before the remand, which technically because he was taken into custody as an arrest, the whole time he was basically delinquent with his battery going on and off. I don't think that's necessary. This is not as though he absconded. This is not a situation where he was committing crimes during that period of time. This is a situation where he was, if the allegations are true, not charging his battery to the best of his ability. I don't think that's a reason or serious enough to incarcerate someone. This is his first violation. Thank you very much for your time and consideration.
Thank you. Just going to take a moment. I'll let you know my findings.
Can I say anything?
I wouldn't, sir.
Okay.
Unless you have something to add that I didn't say.
No, sir.
Okay. Thank you. You don't mean to be rude, but anything you say can be used against you as an admission of the conduct or anything that happened. So I don't want you to give testimony against yourself, okay?
Right.
If it was something I didn't say, that's a different story.
Yeah, the GPS shutdowns was I was at work. And,
okay.
I have pay stubs and everything that Officer Davis has to prove I was at work, and he knows my work. I'm a tow truck driver's assistant. So it was like difficult to charge the bracelet and be,
Who do you work for?
I work for my family owned business. It's Garden Auto Body. It's in
And
East
what are your hours?
My hours, it range from really like on call. Officer Davis knows already. I usually work from like 8 in the morning to like 6 at night. But when a call would come in for a tow or a pickup or anything like that, I would usually go with.
Okay, and is there a way for you to charge your battery in the truck?
They gave me like just about like a couple of weeks before I came in they gave me a car charger for my battery, and I started doing that exponentially good.
Okay, so it improved when you had the car charger, and they gave you a car charger. You have no access to buying a car charger, right?
No, sir.
You can't buy a car charger that's going to work with that device, correct?
Right, sir. I can't.
It was a specific car charger that you were given by Parole.
Yes, sir.
Okay, all right. So they obviously knew that's what was going on. It appears as though, for at least some of it. Okay, thank you. And even because of that now, even for more reason, I don't believe that the violation is sufficiently serious enough to require a revocation hearing and further incarceration. Thank you.
Just one moment. Okay, so for charge number 1, condition of GPS, I identified this charge as 50 separate parts. For part number 3, associated with the date of June 24th. Did I do that right? Number 3, does that sound good to you,
Yes.
Attorney? June 24th, 2024, I am making a no finding of probable cause, as I do not believe the state submitted sufficient evidence in support of the charge. However, for parts number 1, 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15, I am making a finding of probable cause based on the evidence submitted by states exhibits B, C, E, G, and I. For charge number 2, condition of obedience to the law, I'm also making a finding of probable cause based on states exhibits B, E, and F. And on charge number 3, condition of notification of arrest, I'm making a no finding of probable cause as the state failed to submit sufficient evidence in support of the charge. And I do not believe the elements were met. So that does conclude the fact finding portion. I am finding that the act is also serious enough to warrant revocation. So I've determined that you should be detained while you wait for your revocation hearing, which will be scheduled upon the disposition of your criminal charges. The records at the facility you're at will be notified of this, and Officer Davis is now aware of it as well, okay? So once those charges are disposed, we'll schedule you for a revocation hearing once we receive the information from Officer Davis, okay?
Can I just briefly say something to my client because he doesn't know?
Sure.
So, sir, because you were given a PTA and a summons, okay? Court did not know in London that you're incarcerated. So if I called the courthouse and spoke with the clerk, so they will be getting you in for your court date. So they're not going to just sit in jail. I let them know you were in jail, even though there was a PTA. And when you get there, I also notified the public defender's office, apply for a public defender, okay?
Yes, sir. Appreciate it.
You're welcome. You're welcome. Good luck, sir.
This does conclude a preliminary hearing for Mark Gardner, inmate for 374513. I'm sorry, I cut you off. Are you okay? You're good, Mr. Gardner?
Yes, I appreciate all 3 of you guys. And what's up, Officer Davis?
All right, take care, Mr. Gardner. Good luck.
Too.
Have a great time.
You too.
They're waiting for you after that. You might can just go straight that way. And I'm just waiting for Lozado to get here. Thank you.
Perfect. Thank you.
You're welcome. Have a seat, right?
There we go. All right, I thought it messed up my recording. Good afternoon, Mr. Lozado. How are you? Lozado, sorry.
Trying to feel better. I caught the flu.
Oh, I'm so sorry. Is it going around up there? You guys all seem kind of off.
The whole jail.
Yeah, I believe it. Well, hopefully it'll feel better soon. So I am Parole Officer Tricello, and I'm the hearing examiner at the Board of Pardons and Paroles. And this is a preliminary hearing concerning Angel Lozada, inmate number 428584. Today is Monday, January 27th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Angel Lozada, 428584.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this afternoon is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Anna Dean on behalf of Mr. Lozada. Good morning, sir.
Good morning.
So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and you determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Lozada, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have the opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I'll inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, great. So you do have some rights for this hearing, and the first right you have is the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yeah.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
Great. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Okay, so bear with me, it's quite a bit. All right, so on charge number 1, condition of GPS, the charging officer reported that on 12/20/2024 at approximately 1:47 p.m., this PO received a one-piece GPS AT1 strap email notification from Allied Universal indicating that you had removed your GPS from your ankle. Upon review of the video surveillance footage from the Watkins halfway house, you were observed at that time in the driveway outside of the halfway house, removing the device from your ankle and throwing it towards the street before running away from the halfway house. The halfway house staff was able to retrieve the device from the sidewalk. This is in violation of your signed GPS agreement. Charge number 2, condition of halfway house placement. The charging officer reported that on November 25th, 2024, you signed out of the Watkinson halfway house at 11:50 a.m. to attend a shopping pass with a return time of 4:30 p.m. You failed to return to the halfway house until 6:35 p.m. and you did not make any effort to contact the halfway house staff to state that you would be late. Furthermore, you returned without the money you signed out with or receipt for spending. This is a violation of your signed halfway house agreement. On 12/4/2024, you signed out of the Watkinson halfway house at 11:27 a.m. for a dental appointment with a return time of 2 p.m. You failed to return to the halfway house at your scheduled return time. Staff contacted the dental clinic and were informed that you did not have an appointment on that day. Staff made contact with you at 3 p.m., to which you stated that you were on your way back. You never returned to the halfway house and did not make further contact with the halfway house staff. This PO attempted to contact you with no response. Your whereabouts in the community were unknown until this PO made contact with you via phone at 8:45 a.m. on 12/5/2024. Instructed you to return to the halfway house. You returned back at approximately 10:30 a.m. on 12/5/2024, and therefore you were unaccounted for in the community for 23 hours. This is in violation of your signed halfway house agreement. On 12/16/2024, you sat at the Watkinson halfway house at 11:01 a.m. to attend an intake appointment at community renewal team in Hartford with return time of 2:30 p.m. This PO was informed via email by CRT staff at 1:06 p.m. that you did not attend your scheduled appointment, returned to the halfway house at 1:45 p.m., and informed this PO that you chose to spend time with your family instead of attending your appointment. This violates your signed halfway house agreement. Specifically, that will only go to location indicated on the approved community pass. On 12/20/2024 at approximately 1:47 p.m., this PO received a notification via email from Allied Universal that you had removed your GPS unit from your ankle. This PO contacted the Watkinson halfway house staff shortly thereafter, instructing them to conduct an emergency count. Staff conducted an emergency count, could not locate you anywhere in the building or on the property. This PO attempted to contact your cell phone with no response. Halfway house staff reviewed video surveillance and observed you exiting the building through the side door without authorization, walking down the driveway, and removing your GPS unit prior to running down the street away from the halfway house. This PO continued to make attempts to contact your cell phone with no response. This PO made contact with your girlfriend and godmother, who denied knowing your whereabouts. Local hospitals and police departments were contacted with negative findings. You never returned to the halfway house or made contact with this PO. Your whereabouts in the community were unknown until 1/7/2025 when you were located by Parole staff at your girlfriend's residence in New Britain and taken into custody of Parole staff. In charge number 3, condition of mental health evaluation and treatment. The charging officer reported that on 12/16/2024, you signed out of the Watkinson halfway house at 11:01 a.m. to attend an intake appointment at community renewal team in Hartford with a return time of 2:30 p.m. This PO was informed via email by CRT staff at 1:06 p.m. that you did not attend your scheduled appointment. Upon this PO's reviewing your GPS points, you did not report to CRT on Market Street in Hartford and instead appeared to be at a residence on Zion Street in Hartford. This is in violation of the condition of mental health evaluation. The state has filed the following exhibits. What did I do? I had to remark them. That have been remarked for identification purposes. So I have Exhibit A, a notice of parole violation. Exhibit B, a notice of parolee rights. Exhibit C, a remand to actual custody order. Exhibit D, PCS signed conditions. Exhibit E, halfway house agreement. Exhibit F, residential discipline report. Exhibit G, offender misconduct. Exhibit H, a parole violation report. Exhibit I, a residential incident report. Exhibit J, offender misconduct. Exhibit K, GPS monitoring agreement. Exhibit L, the Allied Universal Position History from 12/16/2024. Exhibit M, the residential incident report. Exhibit N, the offender misconduct, unsigned. Exhibit O, the email correspondence from community renewal team. Exhibit P, an offender misconduct, unsigned. Exhibit Q, Allied Universal event history from 12/20/2024. Exhibit R, the Allied Universal Position history from 12/20/2024. Exhibit S, the residential incident report, and Exhibit T, video clip from Watkinson house, halfway house surveillance camera from 12/20/2024. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents?
Yes, I have.
Perfect. I have not received any exhibits from the defense. Is that accurate?
Yes, if this does go to a revocation hearing, we would submit some exhibits.
Okay, thank you. So at this time, we do not have any witnesses, so it is the defense's opportunity to respond and make a short statement, call me witnesses, and testify with respect to probable cause.
Yes, thank you. I just have some brief comments. As to the second charge, there's just a couple things I want to note. First, the narrative for that charge indicates that my client's whereabouts in the community were unknown from that 12/20/2024 date forward. However, based on speaking with my client, we believe that Parole did know where he was the entire time. When he was remanded, he indicates that he spoke with his parole officer who told him look, we knew you were here. We wanted to get you through the holidays, give you an opportunity to be with your family prior to remanding him. So I would just argue that they did know his whereabouts. Second, I do just think it's worth noting, this is my client's, I believe, first time home since suffering a very devastating loss. He did unfortunately lose his mother while he was incarcerated, and that is a situation that he is still grieving to this day. So he is somebody who is wanting to do better in the community. This isn't a situation where he picked up new charges. He's been doing well. He didn't get any new cases. He was not charged with absconding in this situation either. I also think it's additionally worth noting that he has a very large network of support in the community at this point. I believe he was lacking before. That includes his girlfriend, Miss Paul, and other family members, including Mr. Rodriguez, who want the best for him. They want to challenge him to do better. If released back into the community, I do believe he now has a support system that will hold him accountable and help him succeed in what he hopes to do. So I would ask that if the finding is made, that he be considered to, handle this in the community rather than in incarceration.
Thank you. I'm just gonna take a moment and let you know my findings. So I am going to make a finding of probable cause for charge number 1, condition of GPS, based on the evidence presented in the state's exhibits D, H, K, Q, and T. For charge number 2, condition of halfway house placement, I've identified it as 4 separate parts, and I'm making a partial finding. So for part 1, dated 11/25/2024, and part 3, dated 12/16/2024, and part 4, dated 12/20/2024, I'm making a finding of probable cause based on the evidence presented in state's exhibits D, H, E, F, G, M, O, Q, and S. For part number 2, dated December 4th, 2024, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge, and therefore I do not believe the elements were met. And for charge number 3, condition of mental health evaluation and treatment as deemed necessary, I am making a finding of probable cause based on evidence presented in support of the charge, which is states exhibits D, H, and O. In addition, I am finding acts are serious enough to warrant revocation, and I've determined that you should be detained while you await your revocation hearing. So the records and in the facility area will be notified of this, as well as your parole officer, and your revocation hearing will be scheduled within 60 business days of your remand. All right, Mr. Lozada, do you have any questions?
No, I don't.
So if you want to call my office, Mr. Lozada, you can. We're going to get a secondary hearing, a revocation hearing that has a higher standard of proof where we'll submit additional evidence. My social worker will also reach out to you prior to that hearing, and I will contact your 2 family members as well to get info from them, okay?
All right.
Thank you very much.
This concludes the preliminary hearing for Mr. Lozada.
Thank you too.
428-584. All right, good luck, Mr. Lozada. Feel better.
You too, mistaken.
Thanks.
Yeah.
All right, guys. It looks like this stream has come to an end. Let me check. Let me just confirm here that it's over already. I am gonna start up Arizona court in about 33 minutes. I'll add a redirect to the link if you guys want to join. Let's see here. Copy. Let's see here. All right, guys. Yeah, it is over. It's come to an end. I'm gonna go ahead and end the stream. Really appreciate you guys tuning in. I am Collect Call James, and you are watching You Have a Collect Call From. And like I said around here, life's like a candle. Once you blow it out, it's lights out. And with that, we're about to be out. Hey, what's up, M Star, Mad Max, and everybody else? Shout out to everybody. All right, you guys have a good one.